Good morning, good sir. Good morning. कोई और नहीं है, उधर से बंद है. Good morning.
खोले ही नहीं.
One. This is from portal number 1.
Yes. Good morning, Kusma sir.
So
Just
what you
check.
want, madam?
Court started?
So around 11:15, madam.
11:15. Thank you, Kusma. Thank you, sir. चलो आराम से.
Sorry, keep you waiting. Because of some other work. Yes. Yes, sir. Can I mention? Likely to reach. Wait, hope that it will reach.
My lord, may I
I'm
mention?
I'm mentioning one matter, my lord. One new PIL. The problem here, my lord, is there is a tender that is invited. Of course, we're not interested in the tender, but the problem, my lord, is there is a huge amount of private data which is going to be handed over, my lord, to certain contractors. That is private personal data of individuals without any oversight whatsoever. Without any oversight. My lord, there are two enactments which are relevant, my lord, the Information Technology Act and the SPDI rules, which mandate the mechanism by which it should be done. The tender provides that the Data Protection Act, which has not yet been notified by the central government, will apply, which means, my lord, the tenderers will have a free hold over personal information of individuals like us, because this entire banking system, my lord, information is being handed over. And that is why, my lord, we are on only one specific issue, and that is if they comply with those two requirements of the law, which is mandated, which they have excluded in the tender. My lord, the prayer in our petition is satisfied. That is all we are asking for. And they're finalizing that tender now.
So when the tender is going to be?
I'm told, my lord, end of the week.
End of the week. 25th we meet.
25th.
My lord, may I with the
Yes, yes.
my lord, may I with the permission of my lord's mention?
Yes.
And item 15, my lord, I am talking from Delhi. My lord, I have been coming for this case, but on Saturday, my wife was rushed to emergency and she is admitted for procedure for pancreas. And I apologize to my lord. I have informed the opposite lawyer, my lord, if a date can be given. Item 15, my lord.
15, 15.
15, my lord.
So whichever you date you want in the after
Because
first week of November.
she has to undergo for two multiple procedures.
No difficulty, but which date you will prefer?
The
11th of November?
My lord, could it be if it is December or something?
December, no difficulty. Then choose your date and tell us.
Something like December 17 or 21st January.
17th December.
21st January, my lord.
At the request of learned advocate. Made online. From extend over to 17th December.
My lord, serial number 33, my lord.
We complete this so that otherwise.
R.K. Narula.
Yes. 17th December, Mr.
My lord. R.K. Narula, my lord.
What is it?
My lord, I'm the respondent. I'm from the same office here. I'm finding the memo for this.
Memo?
Documents. Medical records.
Not necessary.
Much of like.
Yes,
Any mention through VC, sir?
yes, yes.
Serial number 33, my lords. We are going
17.
to compromise the matter. 2 weeks time may be granted, my lord.
Only granted. The 23rd of November.
Much obliged, my lord.
17 or 70?
33.
Serial number 33, my lords.
33.
33.
33. What is it? Oh, let it go. Give December. Let it go in December. 2nd December.
Much obliged, my lords.
My lord, one matter for posting, my lord, PIL, my lord. The temple's land has been misused by some group of people, my lord. So, my lord, we are filing the PIL, my lord. Fresh matter, my lord.
6th of November.
Your Lordship, matter pertaining to the encroachment on the lakes and Tormont drain. The report was sought by this court on 4th September 2023 itself, Your Lord. Now, for the past 1 week, Your Lordship may kindly say how the Bangalore is being submerged, and they are not cleared any encroachment on the Tormont drain specifically. I'm requesting the matter be listed tomorrow, because the main matter is
13th November.
regarding a lake. It is listed on 2810.
13th November.
My lords, kindly, my lord, serial number 25. I have received instruction yesterday to appear in the matter, my lords. Would I please pray that the matter be taken up on 5th of November, my lords? I am led by senior. It's a commercial appeal, my lords. We'll address submissions.
Fifth of November.
Please, my lords. I filed wakalat yesterday. Great.
How dated is it?
Tomorrow at 2:30.
My lord, serial number 55.
Dated.
There's no urgency. Then you'll wait and you'll come. Wait for 5. Just file for 3 months. 12th November.
My lord, I profusely apologize if I may mention item 15 once again. My lord, I am advised
Next week, my lord.
From tomorrow, after physical mention over. Yeah.
Matter for orders.
What?
Compliance not done, my lords.
14th November. Yes. Not.
Scheduled date is 22nd. Compliance has not.
Then wait, it will be automatically listed.
29th, 30th.
If we give date, we'll give after 15 days. If you wait, it will be listed after 5 days.
He is aged about 82 years. Short date, my lord. First week of.
Out is 2nd December. Yes,
Serial number 96.
2nd December.
Withdraw this. Serial number 96.
90?
96.
What do you want?
Withdraw the act pressure.
Pardon? What do you want?
Withdraw in this.
Withdrawal.
Learned advocate
Serial number 96.
96, learned advocate, Mr. You are Chicana,
Yes, sir.
Mr. Chicana. Tenders memo. Seeking permission to tenders memo dated 23/10/24 stating that the appellant wants to withdraw the appeal. Permission is granted, dismissed as withdrawn. All the interlocutory applications will not survive.
My lordship.
The withdrawal in view of the above order.
Lordship, PIL is filed against my property.
Yes, madam. 40. Yes. 2 weeks time. It is PIL. What is it about? What is it about? What is the PIL about? You're not aware. 5th of November.
My lordship, the serial number 50.
For the respondent.
Pardon? 20.
Number 20. I
20.
appear for the respondent. The petitioner is also present before the court. I request the matter to be posted next week, my lords. It's with respect to a recruitment matter where the examination, negative marking in the examination has been questioned.
There is a delay?
No, ma'am.
No. 18 days delay. 18 days delay.
The original appeal, there's no delay. The connected appeal.
Okay.
That you are
So-
with an understanding for us that they would not proceed in the matter subject to continuation.
25th November.
Yes.
My lordship.
A PIL is
2 weeks adjournment.
Which?
Serial number 84.
18.
About 20.
84 2 weeks. 26th of November. Higher shall stand extended.
My lordship, serial number 58.
Point 1. But the short date, but my learned friend had given an undertaking on the previous date of hearing, not that they would not precipitate the matter and issue appointment order.
That
If
continues.
that understanding continues, my only
That
request,
naturally continues when
That
court
will
is
be
given.
posted next week.
next week.
Not possible. Then we'll pass the order. Not possible to take up all matter at a time.
Or it may be posted on the 5th of November, my lord.
Pardon?
5th of November. Till then, appointment orders will not be issued.
Not possible. 25th November.
Not in that case, not may only make one request. That the submission of my learned friend may be requested on record of the no doubt my learned.
Trust your learned friend. Why? We are trusting. Why should you not?
My lord, I
Lordship.
request for a shorter date, my lord. There is a gentleman's agreement, my lord, it's not recorded.
12th November.
Please.
A
My
PIL
lordship.
is filed against my property without making me a proper and necessary party. So I'm filed IA for impleading myself into the PIL. So kindly hear on IM.
Which PI?
Memo for posting, madam. It's not posted today. I'm just filing a memo for
Want
posting.
PIL to be posted.
Yes.
PIL.
Yes.
What is the PIL?
PIL is regarding a property which is being purchased by myself, which is situated in Hassan. And the third parties are claiming that it is a tank property. So I'm the bona fide purchaser. of it.
26th November.
My lordship, so serial number 58, my lordship, and short accommodation, my lordship. Serial number 58, that is a pollution board.
26th November.
Published, my lordship.
My lord, serial number 29. My lord, appearing for the respondents, my lord. Settlement talks are going
Serial
on.
number?
29,
I appear for the appellant in that matter.
appearing for the
She is for the
respondent.
respondent.
Settlement talks are going on, my lord. It may be posted after Deepavali, around 22nd of November,
We're in the third week of November.
third
if
week
I'm
of
not-
November.
Third week of November. Shall we record that the talks are going on?
Please, my lord, it is also recorded in the
Well-
previous.
Learned the respective parties stated that since talks for settlement are underway between them, the time may be granted. Any of the requests stand over to 28th of November.
Third week, if your lordships could accommodate us.
Third week, 28th,
22nd, 28th.
Where
28th,
Very well.
20,
fourth week.
My lord, serial number 55, my lords.
Pardon?
55, serial number 55.
55.
Yes, my lords. We have filed additional objections in this matter, my lords. The senior is unwell. Kindly seeking short accommodation, my lords. on this.
27th November.
Much obliged.
They are appearing for the respondent number 2 in this matter. In the last, we had made a file a memo stating that we are not going to appear on behalf of respondent number 2 anymore. We request to delete our names from this matter. We request for deletion of the names of the advocates in the matter. my lord.
You,
But-
when it is taken up, you make a request, not now.
My lord, with profuse apologies, may I respectfully mention item 15 once again? My lord, I am told that another operation for my wife is on around Christmas. So could I kindly be admitted for January some date?
21st.
Whatever date you
21st
give,
January?
we can urgent sign and I also. yes.
Please. Serial number
Give
one,
some date in January,
serial number 131.
131.
In that, my lord, the learned single judge has set aside the rejection of nomination paper and has directed holding of election from that stage, fixing the time frame. And the new election would start from Monday, 28th. Therefore, I would
Cooperative society.
cooperative society, my lord. After setting aside the rejection of nomination paper, order has been passed. I would request, my lord, if your lordships could give us 5 minutes time at 2:30 or 3 o'clock or 4 o'clock. my lord.
Elections are held, new elections are going to be held when?
And that is, proceedings will start from 28th.
28th, tomorrow?
No, Monday.
We can take up tomorrow,
Please,
tomorrow at 2:30.
please.
All those which have earlier due for reading. separate.
So contempt matter, seal number 1. So, Venkatachalapati, this case.
My lords, I appearing for accused, the heat section, my lords. I filed my complaint, press for 2
Yeah.
weeks, my lord.
11th November,
Obliged, my lords.
as requested by learned advocate. Mr. Kartikeyan,
Yes, I appearing
for the
for
respondent. Will you see notice, then notice written?
appearing for accused number 1 to 3.
Notice written on 12th November. Learned advocate Mr. So and so appears, waives notice, accepts notice and seeks time to file
All accused.
reply.
All accused.
Serial number 2, Mr. Govind Raj K.
State.
But now when affidavit is filed,
Affidavit has, compliance affidavit has been.
endorsement, my lord, considering my request, but my only request is liberty to challenge the endorsement.
While it was not disputed by learned advocate for the complainant that the endorsement is passed by the respondent authority and therefore the directions of learned assembly are complied with. I prayed that the liberty may be reserved, while closing the contempt, for the petitioner complainant to raise challenge to the endorsement paragraph. The request is reasonable, full stop, as the directions are complied with, admittedly complied with, the contempt proceedings are closed, reserving liberty for the complainant to institute independent proceedings to challenge the endorsement in accordance with law, in respect of merit of which this court does not express any opinion. The petition is disposed of it.
Number 3, Mr. Subramanian.
My lord, serial number 3, I appear for the complainant in this matter. I seek a week's accommodation to file a rejoinder to the compliance affidavit, my lord.
14th November.
Please.
Number 4, Mr. Sampath A.
Compliance, there is a accused number 2 and 3, my lord, has to comply. Now, my lord, the accused number 1, my lord, the PWD officer was to remove the encroachment on the road. Now, my lord, they claim they issued a notice and that notice has been stayed by the learned single judge, my lord. They said. Now, my lord, there is another compliance.
But we have filed a compliance report. This is to removal of the encroachment, my lords. When we issued the notice, the respondents have obtained a stay order against the notice, my lords, which is produced before this in annexure 3, my lords, page 18 of compliance affidavit, my lords. We are not able to proceed with the
So where is that?
Now, my lord, this.
Where is your affidavit?
My lords, we filed it on 29th August, my lords.
29, yes.
My lord, there is another accused, my lord, who also needs to comply.
They were required to consider, decide only, nothing.
No, my lord, the.
So
my lord,
we were
there's another
supposed to
accused.
remove the encroachment.
Where is that direction?
Please, my lordship, kindly, my lord, the order at annexure may kindly be seen for a moment, my lord, please.
Where is the specific direction about removal of encroachment?
Please, my lord, the direction is at page number 10, my lord, the para 5. No, my lord.
Consider the representative.
No, my lord, the second contempt petition
Page.
before page number 8, annexure M. Para 5, my lord, it says.
Para 5.
Please, my lord.
Assign contempt also.
Please, my lord, this. The second contempt, my lord.
Which directions?
That's page 10.
Para 5, it says, my lord, they issued a notice and they will comply the directions. Now, my lord, the notice has been stayed. My lord, secondly, my lord, the.
So this contempt order speaks of which directions to be complied with?
Please, my lord. Now there is a, no, my lord, the. Please, my lord.
The order which are you showing.
Please, my lord.
Provides for compliance of certain directions.
Please, my lord. That is in compliance, my lord, order of the
Which
learned.
are the directions?
No, my lord, the annexure B. Annexure B, my lord, the order of the
What we
learned.
are saying, there is no direction about the encroachment.
Removal of encroachment. No, my lord, there is no direction specifically. That has been stated.
Correct.
My lord, there is second complaint, para 6, my lord, the another authority also needs to take action, my lord. No, my lord, accused number 2, no, at presently, my lord, cannot prosecute because there is a stay. On the notice, there is a stay, my lord, because the other person, my lord, encroacher approached this honorable court, challenge the stay. My lord, the accused number 3 cannot take any action because of the stay. Accused number 2 is the PW.
What you are arguing?
No, my lord, annex para 6, my lord, accused number 2, Panchayat, my lord, has to take action. My lord, against him, there is no stay.
There is a stay.
No, my lord, only against the PW
Go
office.
before that court and say that the stay is limited to this one.
No, my lord, they only
Can't
challenge.
interpret some court's order.
No, my lord, the para 6, my lord, there is no, Panchayat, my lord, they have not taken any action. No, the para 6, I just take
Where
it.
is the direction, first of all,
Please.
for taking action for encroachment?
Please, for PW, my lord, there is no, my lord,
Against any party, where is that direction?
my lord, the direction to consider the representation.
That's all.
Please, my lord, though, my lord, they consider and they issued a notice that has been stayed.
That's correct.
Please, my lord, there is another direction on the another authority that is Panchayat.
Where is that direction?
Please, my lord, annexure B, my lord, page number 12. Annexure B, page number 12.
That is same, we are on same order.
Please, my lord. Para 5, my lord, the order of the learned single judge in writ petition. Page number 15, para 9, para 5. Directing the 5th and 9th respondent to consider the representations dated so. My lord, the 5th is, my lord, the Gram Panchayat. And my lord, 9th is, my lord, the assistant executive engineer, who, my lord, action has been stayed. No, my lord, against Panchayat, my lord, that has not been stayed. Panchayat was remained silent.
What is the direction to remove the encroachment?
My lord, in the contempt petition, my lord, they stated para 6 may kindly be seen, my lord, in contempt petition, page 11, para 6. My lord. My lord, they undertook that they will take action, my lord, para 6, my lord, page number 11. Page 11, para 6, please, my lord.
Page?
Page 11, para 6.
Para 6.
Please, my lord. The learned advocate so and so for accused number 2 also stated that since the construction put up is without license, Gram Panchayat has already taken steps for considering the issue in the next general body meeting of the Gram Panchayat, which shall be held within 2 weeks. No, my lord, Gram Panchayat did not do anything. My lord, the contempt survives against Gram Panchayat, my lord.
May I make a submission?
Not necessary.
Against accused number 3, my lord, because of stay cannot be prosecuted.
Lord learned advocate Mr. So and so for the complainant and learned additional advocate, government advocate Miss Pramodini Kishan for the respondent state and its authorities. The present contempt proceedings is a second round. The original order, subjected to contempt jurisdiction, came to be passed on 6th September. Learned a single judge in the writ petition number 52716 of 19, in which the following direction was received, which is the basic direction for the purpose of exercising of contempt jurisdiction. And paragraph 5, page 15 of it approach. It appears that against the said direction, in respect to the said direction, contempt petition was filed, which was number 607 of 2023. It came to be disposed of by order dated 4th March 2024. A statement was made by learned advocate, learned government advocate, that the directions will be complied with within 12 weeks. Further stating that the notice was already issued to be alleged contempt. On behalf of the Gram Panchayat, a statement was made that accused number 2, that construction was put up, construction which was put up was without license. And the Gram Panchayat has also been considering steps for the issuance of necessary notice in the next general body. Necessary steps in the next general body meeting of the Gram Panchayat. Full stop. Today when the present proceedings come up for consideration from a learned additional government advocate invited attention of the court to the compliance affidavit. From the said affidavit, it was pointed out that the respondent authorities have already taken steps for removal of encroachment pursuant to the direction to decide the representation of petitioner as passed in the writ petition. It was further stated that the said notice came to be challenged before this court.
Please,
Before this court.
before this honorable.
And this court has stayed the said notice. Full stop. This spectrum could not be disputed by learned advocate of the petitioner. In the aforesaid view, when the authorities have acted upon in the direction of compliance of the order of learned single judge, however, the notice issued is stayed, the contempt jurisdiction is not required to be exercised, is not attracted at this stage. Full stop. The parties will be guided by the final outcome of the proceedings in which notice is served. The present contempt proceedings are.
Well, it's my only clarification was only again 2 authorities has to take action, Malu.
So, learned advocate for the petition submitted that Gram Panchayat, there is no
As not-
stay against the Gram Panchayat.
Please.
Therefore, the Gram Panchayat is bound to comply with the direction.
Please,
Full stop. This submission is misconceived in 2 respects. Firstly, there is no direction against the Gram Panchayat expressly given. Full stop. Secondly, it is not possible to come to a conclusion that the state does not operate against the Gram Panchayat. Therefore, the submission is rejected. Next.
Number 5, so Kiran Kumar DK.
Not
Number
yet.
5,
Then 16th of 21st November.
number 6,
In this case, I appear for the
Daniel
complainant.
Yes.
I have challenged the order at contempt has been filed on the order passed by the learned single judge, which is at Annexure A in page number 12, my lords. I filed a writ petition seeking mandamus against the respondents, that is the accused herein, for mutating my names in the RTC entries, which came to be allowed.
The so and so appeared online to invite attention of the court to the order brought under contempt and the directions issued therein. Notice returnable on 2nd December.
Much obliged.
seal number 7, Sridhar Prabhu.
Lords, I appear for the complainant, my lords. The complainant in this matter is a retired economics professor, my lords. We're challenging the single judge order that's produced in Annexure A. If I may persuade your lordship to ink page number 26, the my lordship, am I with you, my lordships? Para number 14, the learned single judge had stated this court has noted that the syndicate's resolution clearly supported the petitioner's claim to the OPS. OPS in this case, my lords, is the old pension scheme, my lords. This university has already refunded the petitioner's contribution under the NPS, which is the new pension scheme, with interest, reinforcing the syndicate's decision. The impugned endorsement issued by respondent number 2, which is the university and the accused in this matter, my lords, which contradicts the syndicate's resolution, is deemed unsustainable, my lords. Based on this learned single judge's order, my lords, we have submitted representations to the accused, my lords, which your lordships will find at page number 109.
2nd December. There is no specific direction, still we are issuing now.
My lords, the learned single judge had quashed the
No consequential direction. Anyway, Will not be that technical. Yes, next.
Petition number 8 to Kumar D.
Challenging the single judge order, my lord, which is at page number 18, my lord. Page number 18. Lord single judge are directed deputy commissioner and municipal council to ascertain that the public property is not encroached by the respondent number 6, my lord. Subsequent to this order, my lord, we had submitted the representation on 7/8/2024, my lord. Till today, no progress has been taken place, my lord.
Notice written on 27th November.
Number 9 to Vasant Kumar HT.
Complaint, my lord. On the impugned order, which is annexed A, page 11, my lord, there is a direction to the BDA to determine the cital value as on the prevailing rate and require the formalities within a period of 2 months. And my lord, after giving such directions, no action has been taken, my lord. I have determined the cital value and paid the entire cital amount after giving the directions, my lord, which is annexed B, my lord. Even after accepting that cital amount, the kept court remains silent, no action has been taken, my lord. And also made representation annexed C.
28th November. Notice.
So PL matters number 10.
My lord, may be permitted to appear for respondent number 3, my lord, who conducts the Kambala, my lord. My submission is that, my lord, anyway, on 26th, there is no program we are conducting.
There is no program.
No, my lord. It will be conducted after November end, my lord. Fresh date.
Newspaper reports clearly indicate, my lord, that it is on 26th.
Based on newspaper reports, they have filed, my lord.
Then we record the statement.
Yes, sir.
Point out, my lords, saying that, oh, your Lordship may record also saying that as of now, it's working. And tomorrow I should.
I have one request, my learned AG, my lord. If they are giving permission, let them give us intimation of the fact that they are giving permission. So that then I can move your lordships, my lord, immediately. That's all I'm asking, if you're giving permission. So that will sort that problem out.
You are appearing for?
Respondent number 3, my lord, Bangalore Kambala committee.
That is the committee which organizes it in Bangalore, my lord.
What happened last year, we have given permission, my lords. We'll place before your Lordship all the permission which we have given in accordance with law, my lords. And only question is with regard to petition is cruelty, my lords. Supreme Court has dealt with that issue and done it. Now the question is, my lord, whether it is, we should do it only in South Kannada, Dakshina Kannada is the other question, my lords. My lords, this is culture of state of Karnataka, which has arisen. It's not that we have to keep it to Karnataka, we can take it not only Karnataka, all over India, all over the question is whether it amounts to cruelty to the animal. In fact, horses are imported from different countries. And when horse races are done, they move from state to state.
We will examine all the issues raised by both the sides, but when? That is the question.
Any date convenient to your Lordship, my lords, I can assure my lords. I think before anything is done, we'll keep your Lordships informed. We'll keep your Lordship, without your Lordships, thing will know.
That's
So
all.
that
If that statement comes from my learned friend, lord, then I will not. Since the AG is saying it, I don't have anything. And one side. Anywhere he said. So they do it anywhere.
Petition for the petition.
People are not really hands-on now.
Kiran, it can be after 2 weeks.
We intend to focus on finding.
ಗಟ್ಟಿಯಾಗಿ ಹೇಳ್ರಿ ಗಟ್ಟಿಯಾಗಿ ಹೇಳ್ರಿ ಅದಿಲ್ಲ ಪ್ರೇಯರ್ ನೋಡ್ತಾ ಇದ್ದಾರೆ ಪ್ರೇಯರ್ ನೋಡ್ರಿ ಪಿಟಿಷನ್ doesn't survive. ಇಂಟರ್ ಮಾಡೋರು ಕೂಡ ಇಲ್ಲ ಅದಕ್ಕೆ ಇಂಟರ್ ಮಾಡೋದು ಕೂಡ ಇಲ್ಲ ಏನು 26 ಅಂತ ಹೇಳಿದಾರ
The petitioner, you have stated in the petition that is going to be held on.
I filed an additional affidavit, my lord. If your lordship kindly comes to page 8 of the affidavit placing on record subsequent events, the dates are there. 26th October, Bangalore. Page 8 of the subsequent.
The petitioner organization named People for the Ethical Treatment of Animals into bracket PETA, bracket over, comma, India. This court.
ಇಲ್ಲಿ ಇದೆ ನೋಡಿ 26
With the
ಅಂತ ಇವರೇ
present
ಕೊಟ್ಟಿರೋದು schedule.
public interest petition seeking to restrain. Response number 1. State of Karnataka, Department of Animal Husbandry and Fisheries,
Yeah, this is it.
from issuing permission for holding the bull
Right.
races known as inward comma,
Yeah.
Kambala,
No, no.
inward comma, over. Anywhere outside the rural areas of Dakshina Kannada and rural areas of Udupi districts of Karnataka, where the Karna, from according petitioners, is held as a part of tradition and culture. The petitioner thereby want the court to enforce the provisions of the Prevention of Cruelty to Animals Act 1966 as amended by the Prevention of Cruelty to Animals into bracket second Karnataka Amendment, bracket over, Act 2017. And the Government of Karnataka notification dated 14th November 2017. As also by relying on the observations of the Supreme Court, of the decision of the Supreme Court in the Animal Welfare Board of India versus Union of India 2023-9 SCC 322.
Lordship, can you record that?
Petition was argued for some time yesterday, showing the urgency that the event Kampala is going to be organized and held on 26th of October 2024 at Bengaluru. Full stop. At the request on behalf of Respondent 1, comma, the petition stood adjourned to today. Paragraph. When the petition came up for hearing today, comma, a statement was made by learned advocate Mr.
Vinod Kumar for R3, respondent number 3, man.
What's the good name?
Vinod Kumar, yeah.
Vinod Kumar, for response 3, who are the organizers of the event, comma, that the event Kamala is not going to be held in near future.
No, on 26th, your lordship may mention, because as per the schedule, what is given is on 26th.
It shouldn't be on 27th.
On 26th.
Or any other, or your lordship also may record, no application has been asked for the state for conduct of con.
6th, on 26th. October 2024, since. And that even any permission is not asked for, applied for by response 3 to the competent authorities for holding such event. Learned Advocate General, Mr. Shashikaran Setty, paragraph. also appeared to pray for time to respond to the petition by filing a counter. In view of the statement paragraph made on behalf of Respondent 3, that the event in question is not going to be conducted on 26th, and that the permission is also not applied for the same, comma. The consideration of the petition could be deferred as prayed for. Full stop. Stand over to 5th of November.
5th.
Full stop.
9th.
Expected that
There is only one more concern, my lord.
since the statement is made, comma, since the petition, since the application is not made to the competent authority for holding the event, and since the state is going to file reply to the petition. No precipitative.
Well, that may not be required because, my lord, we are before your lordships, my lords,
comma,
and between, it will,
reply.
it's more than
Then don't
contempt.
write that, 5th of November. Also, at this stage, learned senior advocate Mr. Dhyan Chinnappa submitted that if the permission is to be applied for in the meantime, and if to be granted, the petitioners may be intimated well in advance. So
Yes.
that the well in advance, full stop. It is so directed.
Please, my lord, that.
I have only one
that
request,
will be
my
fair.
I have only one request. Now they are organizing it in a place called Pilikula. Now, my lord, the location is no difficulty there because it is in Dakshin Kannada, but it is right next to a zoo.
No, they are,
1 minute, 1 minute.
no, they are holding it Bengaluru. That is your objection.
One objection. The second was Shimoga, and the third one was Pilikula. Pilikula, my lord, there's no objection in holding it there, but you can't hold it next to a zoo because, my lord, the zoo director.
You are arguing a different petition.
Yeah.
I've raised 3 issues, my lord, in the petition. First was Bangalore Shimoga, which is outside the location.
No, whatever is pleaded, raised, we'll consider on.
Where-
But is it going to take place, Mr.? Why you are so, what is the event going to take place so soon?
Yes, 9th of November.
So your lordship may decide on 5th of November, my lord, all the
It's
issues.
going to be held on 9th of November.
9th of November.
Yeah.
Know that.
Let me know. That's the second date. First date is in Bangalore.
No, the
Next
first
date
date
is in-
No, no,
Factually incorrect statement has been made, my lord.
No.
Because 26th of October is incorrect statement.
Only anxiety is that we are adjourning this to 5th of November. In the meantime, anything
Nothing is going to happen till 5th of.
So that
I learned from
Everything-
assurance is enough.
other again, things will erupt and.
That's true.
My lord, as your lordship pointed out, his case was Bangalore. Now we are saying that he came on a paper publication which was inaccurate. Now I'm not saying, my inaccurate paper statement. Now having said that, where it's not going to be held, my lord, so we will file our objection. Matter can be heard on 5th, my lord, and your lordship may take a decision on that.
Very well. I can only act on what I have in the public domain.
9th it is going to be held when?
From the paper publication, which my learned friend is saying is wrong, in a place called Pilikula, which is next to a zoo. And the zoo director has written, that's in Dakshin Kannada. Dakshin Kannada.
There you have no objection.
No, I have no objection in principle. But the zoo director has written a letter to the district administration saying the entire zoo animals are a threat with all the noise that is going to happen there. There's a letter, it's not my statement, a letter from the zoo director.
Not part of the pleading.
It's part of the additional affidavit. No?
It is part of the.
Part of the
We'll
additional
reply
affidavit.
to that also, my lord.
Yes, yes.
If your lordship may have it on 5th, we'll reply.
I'm grateful.
So when contested matter gets adjourned, the court feels relieved.
No. In fact, Manoj, that is what I told my landlord. If I don't come, unless it's urgent, we will not trouble your shop.
Because I was-
Pressure on your lordship to hear a matter.
I only cursorily knowing about this Jalakutti and judgments. Then I yesterday went through the judgment, since you were to argue.
I was hoping my learned friend would finish it today.
No, we'll finish it. That's no problem. But not under pressure of
We'll
saying that.
decide.
I'm grateful.
Please.
Writ appeal matters. Bill number 11, the Syed Kashif Ali.
I appear for the appellate. Lord, this is in respect to disciplinary action taken by my lord the bank against respond number 1, whereby for serious charges of misconduct, my lord, he was imposed with the punishment of removal from service. Now, my lord, the learned single judge has set aside the order of punishment on 2 grounds, my lord. One, that investigation report and certain other documents which were called for, which in fact were not relied upon by the inquiry officer or even by the presenting officer in the inquiry, has not been supplied, and therefore that has caused prejudice. That is one ground. And the other ground, my lord, is that this matter was also, my lord, taken up by the DRI, my lord. Therefore, before the DRI, the bank had taken a particular stand. Now, my lord, that had nothing to do with the charges which were
What was the defect in the inquiry report?
Now, my lord, the learned single judge holds that certain documents which were called for by the respondent during the course of the inquiry, those are, my lord, investigation report and, my lord, certain other reports, which in fact were not relied upon, my lord, by the presenting officer or by the inquiry officer for giving his report. All other documents have been supplied. Now, denial of those documents, my lord, the learned single judge holds that the whole inquiry is vitiated.
Page 59 onwards is the reason
Yes.
for the learned single judge.
Since the other side is on caveat, my lord, matter can be heard and disposed of on merits only, my lord. I will file synopsis. You can, lordship may fix a date, my lord. We will close the matter.
Order of penalties of the year 1997.
In fact, my lord, this is the second round. First round, my lord, on the same ground, my lord, the learned single judge had allowed the writ petition. I filed an appeal. Now, my lord, the appeal was allowed. And, my lord, the matter went to Supreme Court. Supreme Court did not set aside the order of the division bench. Please see, my lord, what the Supreme Court does. Good. Sir. Authorities only. My lord, page 25, my lord. Kindly see, my lord, in the first round.
Some 10 documents are not clear.
Yes, 7 documents.
7 documents.
In fact, my lord, kindly see, my lord, the earlier round also, on the same ground it was set aside. Then, my lord, appeal was filed. Please see the order that I have filed before my lords, my lord, the separate, I filed it today, my lord. The division bench has considered this.
When did you retire? On which date?
My lords, I
Date
retired.
of superannuation.
I retired, my lords, in the year 2009 to after there is after immediately after the earlier order of the date of retirement is, my lords,
No, we only want to know the period of 50% back wages.
50% back wages, my lords, that is just
all
for this
consequential
purpose, my lords. Petitioner was under suspension. Then, my lords, he was getting 50% salary as the subsistence allowance. He retired, my lords, somewhere in the year, that is, he would have superannuated in the year 2001. 2011. 2011, man.
And dismissal was, removal was?
Removal was in the year 1997.
Yes, February 97.
For what happened was, learned the division bench remanded the matter to the bank to conduct further inquiry.
The
To the
order, my lord,
single judge, my lords,
order,
remanded the matter to single judge. Even if the earlier judgment was accepted by the bank and the re-inquiry was held, they would not have been able to complete it before 2011. Therefore, my lord, what the learned single judge has ordered is, until the date of retirement, treat him as under suspension. That is, in fact, 50% of the back wages, which would be the subsistence allowance he would have drawn. And that is, and thereafter he will be entitled for pension. That is the sum and substance of the argument.
What amount will come, will amount?
My lords, I'll calculate and I'll make my decision.
my lord,
Again, there is no question of reinstatement.
yes, no, my lord, the charges were serious, my lord.
Charges
Were grave. In fact, my lord, what had happened was,
there is no charges for defalcation of money.
no, my lord,
No charge of defalcation.
my lord,
The only charge is that they said that I have colluded, that the inquiry officer held is not proved.
Colluded and some irregularity in opening.
No, my lord,
Yes, no, there is.
no, my lord, allowing hawala transactions, money in gunny bags were found. DRI raided it, and this person was allowing them to
Bank-
hawala transactions.
Bank
Cash.
justifies
Yes,
these
yes,
transactions.
that is how, my lord, the matter.
Bank justifies
came up.
these transactions
charge?
before the DRI.
Sorry, my lord.
Where are the charges?
Yes, my lord. The charge sheet, your lordship will find at page 152, my lord.
The order of the second.
Page 152.
Yes.
At 156, my lord. Statement of imputations. Yes. At 158, my lord, last paragraph, if your lordship sees, last but one, that on 21/2/95, 158, my lord, that on 21/2/95 around 3 p.m., officials of the Directorate of Revenue Intelligence, Bombay, visited the
Where-
branch.
Where you are?
Page 158, my lord,
Yes,
at third paragraph, my lord.
yes.
Directorate of Revenue Intelligence visited the branch and seized cash of rupees 50 lakhs. My lord, this was then 50 lakhs at that point of time. Brought by parties for depositing into these accounts, current accounts, along with another sum of 50.78 lakh being the cash withdrawn by the parties from their current accounts. That on 22/2/95, Assistant Director, Directorate of Revenue Intelligence, Bombay, directed the branch not to honor and issue stop payment instructions in respect of pay orders, demand drafts issued by the branch from the amounts withdrawn from the above referred current accounts, and also further directed not to allow withdrawals from these accounts without clearance from their office. That as on that day, the branch had already passed for payment of 47 pay orders for amounts aggregating 2.93 crores, which are presented in clearing by other banks. However, 19 pay orders for amounts aggregating to 92 lakhs, which were pending for payment, was stopped for payment.
But how do you connect the role of the delinquent with
Yes.
this?
Yes, this is, my lord, without verification, accounts were permitted to be opened. He allowed them to operate these. He granted them all these benefits. That is how, my lord, the inquiry officer comes to conclusion. That is,
Okay, you just calculate the amount and then whether,
I'll calculate and place it before.
and the other will proceed on merits and this.
very well.
12th of November,
2 weeks, my lords.
little longer.
12th November. I'll.
You want little longer?
12th ಆಗ್ಬೋದು.
12th November.
Very well.
This is number 12, Abhijit Verma.
Lordship, this is a continuation of delay application under
Notice written.
Section 5 of the Limitation Act.
So delay, notice.
Notice.
Reading account.
Yes.
Please, ma'am. Lordship, I came to know of the order, impugned order, only on 14th May, when I visited my property. Then they handed over me a copy of this order. So then only after that I could have filed this present.
Which order you are challenging?
Please, my lord. It's the 7th June 2023, passed by this honorable court in the petition number 11640 of 23.
It is interim order.
It's an interim order, my lord. But I am agreed by this order because already there is an injunction order on this property itself in my favor, which has not been challenged or set aside.
Point out to learn a single judge. All this.
Lordship, but I am agreed by that order. That's why I have come in appeal before against that order.
while this latest patent appeal accompanies the application for, while this latest patent appeal accompanies the application for condonation of delay, when the order impugned in the appeal was noticed from the record of the appeal papers, it could be immediately seen that the said order dated 7th June 2023 brought under challenge in the appellate jurisdiction is an interim order. Learned single judge has only issued notice to the respondents, which is accepted by learned additional government entity. Learned single judges thereafter restrained the respondents from interfering with the peaceful process of the petitioner. Place the respondent hearing till the next date of hearing. Full stop. There is no gainsaying that by very nature of the order, which is interim, the rights of the parties are not finally crystallized. There is not wrapping of finality in the order to make it amenable to the appellate jurisdiction. Full stop. In the aforesaid view, this court is not inclined to entertain the appeal itself. Inclined to entertain the said order in appeal. Full stop. The petition is pending at large to be considered on merits before learned single judge. Full stop. It will be open for the petitioner to raise all the contentions, including in relation to the interim order passed, to be considered by learned single judge in accordance with law. Full stop. With such limited observations, the appeal is dismissed. The interlocutory application will not survive.
December 13, Mr. Kempegowda.
Kempegowda.
There is an error in paperwork, there is an error. Because in the order impugned before my lords, learned single judge has followed his principal order, which I had to have filed along with a memo. I am making available that my lords because if my lords would kindly see the order of the learned single judge at page 43, he has only followed these very charges to decided by this court in writ petition number so and so. That writ petition, my lords, no reasoning is there. Reasoning is found in 40064-20016, my lords. That order for my lord's kind perusal, I will take over. What happened is this, my lords. Levy of certain charges by the BWSSB for grant of NOC for applying for building license were questioned. There, my lords, one of the contentions raised was the act and the regulations permit collection of pro rata charges while granting sanction to water connection. And now there is no provision in the act insofar as advance pro rata charges are concerned. That, my lord, the learned single judge holds that earlier in Munswami's case, this court has upheld the levy of pro rata charges. Therefore, the charge is valid. He fails to notice the stage at which the pro rata charges are to be collected, and that there is no provision about the advance pro rata charges. If my lords should kindly see, my lords, kindly take the act for a moment, my lords. What I questioned in the writ petition is at page.
What is the section on it?
My prayer is at page 115. All right.
So this order in your favor?
62. Yes, minutes. In the regarding advance, my challenge is only regarding advance pro rata charges. Advance pro rata charges, I had stayed throughout the pendency of the writ petition.
So direction number 2 only.
The direction 2 only, members. Sought for the petitioner without insisting on payment of the advance pro rata charges. The pro rata charges he upholds by direction 2, that has to be stayed is my responsibility. Because in a writ appeal filed by the direction number 2 only, members. I'm saying, taking-
This can be considered final.
Lord, I will accept notice for respondent number 1 and 2, my lord.
Members, respond,
There is no urgency.
There's no urgency. my lord.
Third of, 4th of December.
my lord's good.
Date of, what is your good name?
K.S. Harish, my lord, government advocate.
K.S. Harish, learned.
My lords,
K.S. Harish, accepts notice.
Direction number 5 has been stayed by this honorable court, my lord's refund in writ appeal filed by the BWSSP. And so the other directions, I am not seeking, I am only seeking about the stay of the second direction because the act, it's in the act itself, there is no mention of any advance pro rata charges.
You want that they will consider.
Yes.
If one direction is state, it will be operating in your case also. Number 5 is state.
Number 5 is state.
It will operate in your favor. No further.
But the current demand of advance pro rata charges, what happens with this month? I am a builder and in every case, the moment I go for NOC, that is at a time when not even building license is sanctioned. Direction number 2 at page 8, page 46.
Direction number?
2, item number 2, my lords. Page 46. These 2 charges, my lords, under the act and the statutory regulations, I am
That will
required to
consider.
pay
No,
only when I apply for water connection.
It was stated by learned appellant that direction number 5, Roman small 5 of the order is already stated in the cognate appeal. Learned counsel for the appellant prayed for stay of direction number 2, which cannot be granted since granting nature of such, granting interim relief of such nature will amount to granting principal relief in the appeal. which is not
That I had stayed throughout the pendency of the writ petition, I had stay, my lords.
All demands and payment counsels remain
My lords,
subject to.
at a time when I apply for.
All demand and payment shall
My
remain
lords,
subject to outcome.
my lords, even before I am sanctioned a plan, if I am required to pay advance pro rata charges.
But it is amount to granting principal relief.
No, my lords, principal relief, what I have sought is, principal relief is advance pro rata charges itself cannot be, but the pro rata charges are bad. Section 59A is bad. In fact, my lord, the stay of advance pro rata charges was something that was
We will hear it on 30th.
Please, my lord, notice to respondent number 3 to 5 has to
30th.
be issued.
Here on near 30th.
30th of this month. That
State appeal.
I appear for the appellant, state's appeal. My lord. Matter pertains to serious contractual disputes pertaining to various invoices, nearly about 348 invoices have been raised, my lord. The first respondent, which is a private limited company, has invoked 226 jurisdiction to seek for release of payment of these disputed invoices. The fact is, my lord, in 2019, short-term tenders was invited for 2019 parliamentary elections, my lord. 3 tenders, the first respondent became the successful bidder and he was required to supply meals, erect shamiana and CCTV cameras were required to be carried out, my lord. That work was performed and nearly 7.45 crores was paid, my lord. The first respondent has filed the petition claiming about 10 crores 81 lakhs as dues under the invoices, my lord. These invoices were subjected to audit and the audit reports were also filed before the court, my lord, which said that invoices are highly inflated. In fact, yesterday, my lord, I have filed an additional affidavit where I have produced the invoices and actual attendance register in that office. The attendance register shows only 43 personals are present in that office. The invoice claims to have supplied meals to 340 and odd persons, nearly about 8 to 9 times the actual strength of the staff itself. So serious dispute pertaining to invoices has been adjudicated by the learned single judge. In fact, in para 13, my lord, of the impugned order, your lordship may kindly see the error, my lord. Page 29, my lord, para 13 of the impugned order, your lordship will see that the learned single judge in para 13 at page 53, my lord, '54, my lord, para 13 of the impugned order starts at page 53, my lord. And in page 54, my lord, about 5 lines from the top, page 54, my lord. In the considered view of this court, there is no disputed question of fact as the invoices and amounts claimed are clear. So virtually, my lord, the learned single judge has certified these disputed invoices in a 226 proceedings, my lord. Your lordship, my lord, even this honorable court in BB Studios case, my lord, has said serious contractual disputes cannot be adjudicated under 226 proceedings.
They held a meeting, but this is, my lords, Election Commission of India directed us to procure. But kindly see, they held a meeting, reconciliation meeting. All these questions were raised. Deputy Commissioner called us and said that we are ready to settle with you, provided you reduce it a little bit. From 15 crores, we reduced it to 14 crores, out of which, according to them, acknowledging that 3 crores and odd was paid. 11 crores was pending. It is at that point in time we approached the court. Before the learned single judge, the only affidavit they filed was there was some FIR filed against me in respect of some other issue. But for this, no objection was taken. Learned single judge relies upon the kindly see the reconciliation meeting which the deputy commissioner themselves held it at my lord's annexure H. Page, my lords, may I request lordships to kindly see, my lord, page 146. And relevant portion would be at page 147.
So it is a contract to supply food.
Food, my lord, for election, my lord, election process.
Election staff.
Parliament.
Election staff.
Now, my lords, they have come up with all sorts of stories. 2019, we are now in 2024. 6 years later, we have spent. Now they want us to testify what kind of food you gave.
But your claim prima facie arises out of breach of contract.
It's not a breach of contract. It was on the basis of an admitted claim made. Release.
Inflated
There was no dispute at any point. No, there was no dispute.
Have you agreed for some amount?
Not amount, the
Page 147.
Tender itself stipulates.
Page 147, Lord. Deputy Commissioner.
May I just make a submission?
I'll just complete this.
Tender, Just
Once
one
it is admitted, page 147, Lordships may kindly see.
Lord, post this meeting, my lord, audit was conducted. And it was found that these invoices have been inflated. It is not that they are out of any remedy, my lord. They have to approach the civil court when there is a dispute with regard
This
to
is
the
very easy,
inflated,
my lord. This is very easy.
inflated invoices, my lord.
This is very easy now, my lord, for us to tell them, for us to tell us to go to the civil court. At page 147, Deputy Commissioner calls a meeting, asks us to reduce it so that he will release it within 7 days. He assures it. But audit report, so-called audit report is as vague as possible. But page 147, 6 Lordships may kindly. And this is post-audit. At page 147, if Lordships get to that, it was informed to all the vendors present during the meeting that the proposal is sent to Chief Election Commissioner of Karnataka on 26 June 2019 itself for the release of the total sum of rupees 20 crores so and so as an additional grant in aid to be released therein for clearance of all the pending bills on the duty refer therein general election in all 7 so and so. Next last sentence. However, all the vendors present therein raised their objection for the said fact and some even informed that already there is a delay in the payment of clearing the bill due to which they are suffering. And now that the fact that the revision of bill would cause severe loss to them. Thereafter, there was a detailed discussion on the subject and finally all the vendors agreed to cut short and thereafter all the vendors present agreed. Page 147. Then the bills were revised accordingly with the cooperation of the vendors and henceforth accordingly mentioned here in below. And they revised the bill notes and the matter actually stood concluded there. In fact, Chief Election Commissioner, who was the principal person, filed an affidavit before the single judge saying that they have no objection for release of the amount. In fact, my learned friend, I think representing the Election Commission of India is also present before your lordships. They have no objection. They have not implemented this through the deputy commissioner, who is the district electoral officer.
The audit is subsequent
And
to
the
this
audit,
meeting.
lordships will kindly see the kind of audit they have made. The only remark is it is too high. In fact, Leonard Single Judgment records the audit report also, bro. But may I request lordships to kindly see page 49.
Nearly 18.5 crores is the amount which 7.5 crores has been paid, my lord.
It is 10 crores.
81 lakhs is now sought. And these invoices have been disputed by us. Their remedy is left open, my lord. But the learned single judge endorses these invoices as correct. Look, this is purely an area that has to be established by leading elaborate evidence.
Your counsel has given concession.
In
But,
fact,
my lord,
he is before your
the
lordship.
election commission, my lord, releases the money, my lord, which is required to be paid by us. But we are supposed to carry out the due diligence in respect of those invoices. We have exercised our right in scrutinizing that invoices and we have raised objections.
The election commission is before your lordship. He says that money can be released.
That has nothing to do with the audit that we carry out. The audit.
My lord, election commission, my lord, what we said, my lord. Yeah.
State election.
No, central chief election commissioner.
So then how can you take a stand contrary to the election commission?
No, my lord, that is with respect
My
to
submission to my lord says, may I submit my submission to my lord says, my lord, after this issue, my lord, the meeting was called by all the district election officers. My lord, chief election officer, what the senior council is saying, my lord, it said that take a decision at your level. Lord, that is not said, we will release the amount. What happens, my lord? Election commission do not have the independent fund. Lord, we call by rely upon the funds by the state government. Therefore, my lord, we informed the district election officer to take the decision at your end. Since he is the authority, my lord, who all the bills are with the district election officer who invited the tender. The deputy commissioner is also a district election officer. Therefore, my lord, the authority is given to him to take a call at your level. Lord, even otherwise also, we election commissioners do not have the independent fund. Lord, we also seek the state government also.
Lord, yesterday I have filed.
But at page 53, in fact, Leonard Single Judge records that the Learned Counsel for the Election Commission submits that the commission has directed release of the amount early and now even after the interim order was passed, the state is sticking to its stand after 5 years. In fact, he records. There was a direction issued to release the amount. And my lord, today, my lord, to come state coming up and saying, we have asked you to go to the civil court, my lord, something, my lord, which would be arbitrary. A learned single judge relies upon ABL International to say, unless there is real disputed questions, that mantra of disputed questions cannot be used to send people to the civil court.
Lord, yesterday's affidavit, Lord, if Lordship kindly takes.
For the first time, all this
I
is being introduced now.
No, it's part of the entire audit process that has taken place. Lordship will see the invoices are produced, my lord. We have produced, the work order clearly says that meals will be supplied to the officers. Now, we have produced attendance registers of two constituency. One is Anekal, my lord, the other is Elanka. The Anekal register shows only 43 personnels are employed, are on rolls. I have produced the attendance register. The invoice which they have raised, my lord, shows that they have supplied food to the extent of 350 persons, 378, 400. What is the basis? Any amount, any persons that they have mentioned, they want us to accept.
My learned friend
They want us, let's complete, my lord.
Does-
They want us not to carry out any due diligence. By what?
File your counter in the main petition.
I have filed actually my objections in the writ petition itself, my lord.
There is that.
And I have filed.
Kindly see the
That
counter.
Lordship will get it, Lord. Along with it, Lord, to audit, the statement of objections have been filed at page 237, my lord. And we had also filed an application submitting these audit reports, my lord. Lord, all that we are
No,
saying,
page
my lord,
237 may be examined, but nothing
But-
of this sort is
but
taken.
all-
Except for saying that the company's name is changed without interfering, without informing us, practically no objection. Kindly see page 237, it's a one-page affidavit they have filed, practically not without any dispute.
Lord, one other dispute is also, my lord. The actual tenderer was DAP Hombale Privates Limited. Now, the writ petition has been filed by another company, which claims to have stepped into the shoes of the Hombale, which subsequently became Chilume and
is the only
Dreams of
objection.
Fountain, my lord. These are blacklisted companies which have indulged in malpractices. My lord, the two FIRs have been registered against them. All that we are saying is, my lord, I have a right to raise a dispute and carry out a due diligence in respect of these invoices, my lord. If I have raised a dispute, my lord, they definitely have to, they have a remedy, my lord. All that I'm saying is the learned single judge in 226 could not have said, yes, I endorse all these invoices. Lord, in fact, which gives no room for anyone to even raise a dispute pertaining to these invoices, my lord. I have produced the application. I have produced the two audit reports. These are inflated bills. Fact that, my lord, he says that he has reduced 80 lakhs straight away from the 15 crores which was due. Also goes to show, my lord, if this supplies had been made. Lord, in fact, my lord, all that I want to say, my lord. Less. In fact, my lord, in one of the Supreme Court judgment, my lord,
Page 823. Applicant himself says food was supplied to everyone.
So completion certificate is also not issued.
not received.
Issued, man.
The
issued.
invoices, my lord, the invoices.
Not, in fact, not learned single judge records that, saying that the deputy commissioner has countersigned each of the invoices. Not, may I request lordships to kindly see, not page 39, paragraph 8, paragraph 8.
Paragraph 7.
Her learned senior counsel for the petitioner in
No,
reply.
paragraph 7 of
Para 8.
your statement of objections.
Yes.
From the bare reading of the conditions imposed in the work order, it is clear that the successful bidder will be entitled to the money bills only if the certificate is issued.
Yes.
by the returning officer enclosing along with the bill.
Yes.
So it is bills are not certified.
No, that is certified at page, kindly see para 11 of the learned single judge's order, para 8. Paragraph 8 of the order of the learned single judge. One name. Every invoice has been certified. That learned single judge holds. All of them were produced before the learned single judge. Para 8.
Para 8.
8. Page 39. The learned senior counsel for the petitioner in reply would take this court through plethora of invoices. At every point in time, they were countersigned by the deputy commissioner, and the state is now wanting to wash off its life by not paying the bill of the petitioner. 5 years have passed, but the petitioner has still got the amount. Everything has been certified. All the invoices were produced before the learned single judge.
No, countersigned by the state
No,
petitioner.
certifying it to be correct. Countersigned to be correct.
It is signed by
Because
the
that
returning officers.
these invoices carry how much food I have supplied on this day. It contains all the details. He countersigns it. The whole idea of a countersign is that he certifies it. Obviously, no, it has to be certified on the same day at the same spot. It cannot be done later on. Because these are all matters where food is supplied. Counter signature. New produce invoice counter signature. What does it say?
You are questioning on what basis?
My lord, one is on the basis of the audit report which I have produced. my lord.
Sorry to. In fact, he certifies. He clearly certifies that whatever has been supplied, I verified it, and it's correct.
Okay, that is what my brother.
Yes.
Lord, Lordship may kindly take the additional affidavit I have filed yesterday, my lord. May I request your Lordship to kindly take the additional affidavit? I have filed it yesterday, my lord. Kindly, my lord.
This has the tenders.
You yourself have certified, assistant returning officer.
But Lord, now these, no doubt these invoices have the signatures of the returning officers, my lord. Today also I have produced the affidavit which says that when these invoices are compared with the actual number of personals who are present in the office, my lord, I have produced by evidence to show that there were only 43 personals on rolls of one constituency, whereas the food is claimed to have been supplied to 350 persons. 43 as against 350, my lord. Every invoices has numbers which are more than are inflated. Now this dispute of inflation cannot be resolved in 226. Your Lordship, in BPP Studios case also,
Additional commissioner. Not this. Additional commissioner. Did you copy them also?
Both of you give your synopsis. This is the
Correct.
only, this is the only point. Give your submissions in writing.
Please, please,
If need be, we are here for the.
please. But he does, I hope he'll not expect me to go to civil court and summon all 400 people. And what is the question I'm going to ask them? Did you eat that day or no? But I mean, this is something which is.
What is the amount?
About
10 crores
10 crores 81 lakhs is what they have sought for, my lord. 7 crores 45 lakhs has been paid to them.
Already paid.
We have already paid 7 crores 45 lakhs.
3 crores.
3 crores. I'm
No,
telling.
no, 7
No,
7
whatever it
crores
is, memo of
45 lakhs.
calculation will file.
I dispute
They
that
can-
amount. We have paid 7 crores 45 lakhs. And they have claimed 10 crores 81 lakhs on the basis of the invoices. And without, my lord, the due diligence has been carried out. Audit has raised objections. Now to say that in a writ proceedings, I endorse this invoices, my lord, would be contrary to the law.
But
Second,
they-
your lordship itself.
With respect, learned single judge has not endorsed it. It is their deputy commissioner who has endorsed that invoice. And 6 years later, my lord, if he asks me to prove whether that person ate the food or not, it will become impossible for me. This has to be done on the spot on that day, which has been duly done by the deputy commissioner. These are all matters, my lord, where there is no evidence available. It's because of food consumption.
Now the difference is of 2 crores only.
No, it's not 2 crores, but
10 crores.
1 second. 15 crores is what was the claim made by us. They asked us to reduce it by 1 crore 45 lakhs. We did so. 13 crores was balance, out of which they paid 3 crores. 10 crore 81 lakhs is the balance.
Lord, according to us,
This is recorded by the learned
my
single
lord,
judge.
we have paid them 7 crores 45 lakhs, which I can place on record. Their writ petition
Not at the
claims
same
10 crores 81 lakhs. And that has been allowed. My lord, may I just pass on the judgment? Only I'm on the point where, my lord, this court has also taken in BBP Studios case that serious contractual disputes cannot be adjudicated. We are not shutting down the.
Here the
remedy of
bills
the-
are certified, that is the thing.
No, my lord, the difference is, we have a right by virtue of a doctrine of public trust itself. Have a duty to do a due diligence. Now, simply because they submit an invoice endorsed by one of the returning officers, do I lose my right to raise an objection? These are public funds. 10 crores 81 lakhs is being sought for on the basis of invoices which we have disputed. What prevents them from establishing these invoices, my lord? When I have the documents to show there are only 43 personals or 54 personnel in particular offices, how could they have supplied meals to 400 persons, my lord, on that day? If he says that numbers cannot be kept count of, then is that not a case, my lord, where it's a pure case of inflation? For mere asking, the amount has to be released to them. For mere asking. And what the learned single judge does, my lord, he endorses this invoices. That is the error, my lord, according to my humble submission, my lord, which could not have been done. Lord, that's why, my lord, the Honorable Supreme Court, by referring to a Chief Justice Neelay in a court, in US court, my lord, I have very few illusion about my own limitations as a judge. I am not accountant, electrical engineer, financier, banker, stockbroker, or a system management analyst. It is height of folly to expect judges intelligently to review 5,000-page record addressing intricacies of public utility operations. It is not a function of a judge to act as a superboard or with the zeal of a pedantic schoolmaster substituting its judgment for that of an administrator. So therefore, my lord,
Academically, it is very interesting.
Lords, there are plethora of cases.
English judgment.
There are
No,
plethora.
no, that, Mr. Counsel, it is very settled proposition and we lean towards it, that in contractual matters, the
Yes, my lord.
that's the consistent view.
civil remedy is the remedy. but
That's all, my lord.
then
It's
we have
settled in
to,
1952.
we have to go a little deep in this case, whether that,
Yes, yes. That
whether it is
principle is
an
up.
My lord, my-
acknowledged bill or.
It was acknowledged, but I'll be in a position to demonstrate. Everything was acknowledged.
I read out at para
Retail International is what
page
the-
44, my lord. Page 44, I read it out. It's a matter pertaining to the
English decision.
English Chief Justice Neelay, my lord, of US court, my lord. Page 44, my lord. Para 44. Lordship will get it in words of Chief Justice Neelay. I have very few illusions about my own limitations. As a judge, I am not an accountant, electrical engineer, financier, banker, stockbroker, or system management analyst. It is height of folly to expect judges intelligently to review 5,000-page record addressing the intricacies of public utility operation. It is not function of a judge to act as a super board or with the zeal of a pedantic schoolmaster, substituting its judgment for that of the administrator. Now, my lord, there are two audit reports which we have placed. My lord, we have disputed. Can the learned single judge, my lord, endorse 348 invoices?
How audit report can dispute it?
My lord, by verifying the attendance register, for example, my lord, your lordship may kindly
Attendance.
take, I have definite records to show what are the number of personals. The work order issued clearly says that you will supply meals to my officers. I have a count of my officers. The invoice does not just states a figure and they expect us to accept
The
it.
first time being introduced, first time, neither before any authority, nor to response, nor before the single.
Because these are
judge, nor
disputed
for the
questions.
first time, they have invented all these things.
Look, they're bound to
Really
answer.
unfortunate, not the state has to be more reasonable to us. But I have taken loan, surface notices have come to us. 2019 parliament election, and not, these are not definite contracts of building contracts. But they ask us to not put up CCTV camera, provide cars, food for all the persons. I can't count and give. But when we open a food stop, there are sort of para-volunteers who come and consume. In fact, I have letters issued by the deputy commissioner who certifies that only certified people cannot eat. There will be others who will come and eat who are engaged for the day. All of them should be provided food. Police personnel, all that is there. In fact, he has certified it.
No, that
And the
statement
state
itself-
comes up with this theory today.
You filed the petition belatedly?
Not belatedly, we have gave 4 representations when there was
5 years.
2019 election, not 3 representations we gave. They did not 2020. 2020 we filed.
Only 20 you filed.
23, my lord.
Not 23. 23.
23, my lord.
23 we filed.
23, my lord.
So 5 years later.
5 years down.
No, my lord, kindly see the representations. We
No,
filed
your
representations,
representation does
meetings-
not extend the
No,
period of
meetings were held,
limitation.
I'm sorry, meetings were held. They were assured of the payment. That is what we pointed out. Chief Election Commissioner also intervened. It was only at last resort we approached the court. That will
All
be our
that,
position.
my lord, my only humble request is, even by virtue of.
There are plethora of cases, my lord, where BBMP, my lord, contractual money is not paid. Courts, my lord, have been approached. They have taken time to release the amount and they have released. This is one such case. But I do not want to go back the reason why they are so opposing so much in this matter. There seems to be, anyway, my lord, I do not want to.
Lord, it's.
No,
there's
let
a-
us not get into that.
Look, there's a saying, my lord, one should not cheat, but it's important, one should also not get allowed to be cheated. By virtue of this inflated invoices,
You are receiving funds from the election.
Election Commission of India.
funds are from them, my lord. But we have taken up a ground that management of public funds is an essential
Nothing to do with that.
work. We, by virtue of due diligence that we are required to carry out, it's a public fund, my lord.
But they are not disputing the entire.
They have, they cannot also, my lord,
May I
because
submit
it is my tender, man. Money is to be paid by them, but tender has been issued by the first.
No, not, in fact,
by the
Election
second.
Commission of India has given a direction to release the fund. But kindly see the order of the learned single judge. There is a communication issued. Please release the funds because nobody will trust us again. Again 24 election, what we were called upon and we were given the contract. 24 election, if we had cheated them, so called that statement. 24, we were given the contract, again we performed.
Lord, what election may I submit, what election commission of India has said, my lord, chief electoral officer of the state. Lord, he said it is an internal communication between the chief electoral officer and the deputy commissioner and the chief commissioner BBMP. Lord, it is at page number 864 at volume number 4. Lord, he said after the interim order,
Volume number 4.
volume number 4, my lord, page.
Did you file your counter?
No, my lord, I have not filed in the counter in the writ petition. My lord, this is the communication produced by the petitioners.
Would you like to file counter here?
My lord, lordship, our stand is very clear, man.
Where is that?
It is in, my lord, 840.
We want your stand from the record.
Please.
From the decision of the Election Commission.
Volume 4.
Please, my lord, volume 4, page number 864, my lord, begins.
Page?
864, my lord.
840.
Translated copy is at 866.
864.
Please, my lord. My lord, translated copy is at 866, my lord. May I request after, lordship, may kindly turn to page number 867. What is the relevant?
No, kindly see 866, last sentence, kindly read that. That is where the direction is issued.
Lord, may I read in the middle of the page, my lord, after the reference? Lord, 867, as described in the above mentioned details regarding the payment of the outstanding bills related to the cited cases, in the meeting held in this office on 23/9, it was directed to review the pending payments of the said cases at your level as per the rules and take appropriate decision and action accordingly. Lord, what we said is that to review the bills at your level and take action as per law. It is not that, my lord, we will release the fund. Lord, Election Commission is
But not only that, but they accepted, no, I'm sorry, they accepted the order of the learned single judge in the interim order. That is what the election commissioner says at
Lord,
document 866 last sentence.
Sir, we review the order, review the pending bills and take action at your level.
This is dated 12th of April 2024. And we have reviewed. The regional commission, office of the regional commissioner has reviewed. The office of the chief election commissioner has reviewed. And they have said these are purely inflated bills. For mere asking, this amount is going to be released. No accountability with number of people who are fed.
There is no direction, that the translation is not correct. It is not review. Please take a decision, is what the Kannada word says. Parishilisi sukta tirmana kaikolbekante, there was a direction. In fact, they say High Court has directed, we require to comply with it. Please release the amount. This is the word. At page 866, last few sentences are clearly shows that they have accepted the order of the learned single judge. Both the interim order as well as the learned single. But in fact, the learned single judge records the statement of my learned friend, wherein he says that unequivocally we have given direction to the state authorities to release the amount. But kindly see the order of the learned single judge. He records that statement. Page 53. There is no question what now are they going back on their words. Page 53. Kindly see page 53. The Election Commission has clearly indicated that the issue should be sorted out within its head. After the interim order supra was passed by this court, the learned counsel for the Election Commission submits that the Commission has directed release of the amount early, and now even after the interim order was passed, the state is sticking to its stand 5 years ago.
May I submit, my lord, that statement?
No, he cannot.
My lord, now with that statement, my lord say that is the communication my lords have seen at page number 864, my lord.
Correct.
That is the reference. After the interim order, my lord, after the meeting, the communication is at 864.
64. Huh? Volume 4.
My lord, reading further in the same paragraph.
Kannada. And now what side?
Satisfied. That's one. Mandates that it has to be supplied. Additional.
And now that lordships are on that word, may I request also?
Give your synopsis, will decide it.
Yes, please. May I just also take your lordship once through the additional affidavit that I have filed?
No, but
Just to
before that,
point out-
before that, since what they are trying to introduce dispute, but I have to meet this so-called ghost of a dispute they are raising before your lordships. Kindly see page 49. What kind of objection they have raised it? But can this be something which it has to be decided by civil? Page 49, not internal page 21. I will meet these objections straight away, lordships, kindly see, which learned single judge says this is ridiculous, these kind of objections at page 21. Kindly see the endorsement. This is audit report for sweep 7,354,000. Considerable value. Yes, remarks nil. Kindly see for food cannot be considered. Lordships get the tabular column. I'm sorry. Lordships get the tabular copy. Number 3, control room, nil. Webcasting, nil. Remarks is nil. Number 5, counting material, cost is high, can be negotiated. 6, polling material, nil, nil, nil. Cost is very high, can be negotiated. It needs to be confirmed by all the ADOs. There is only one aspect. Cannot be considered, cannot be considered, cannot be considered. These are the remarks made. The genuineness of the bills are not challenged. They want to renegotiate the contract now.
No, that's
This is
false.
all the so-called dispute, nothing else. I cannot go and prove something in the civil court in these aspects. Now they come up with all this story.
So the election, parliamentary election.
Parliament election. It's not a small
2019.
thing, Lord. It's the 2009 parliament election. Entire Bangalore city, what 3 constituencies, Bangalore Central, North and South. 3 constituencies.
7 assembly constituency.
So you are acting as the agent of the election.
Election Commission of India.
Yes.
So how can you dispute now? That is the point.
Lord, if we find that the bills are inflated,
And saying that
the
No semblance of confidence.
You are a chief electoral officer, but still for the purpose of parliamentary election, you are the agent.
agent of the Election Commission. He's got nothing to state as
For
per
the
the
officer of the election commission.
Yes.
You
In
are
fact,
not
not in
agent.
the appellant, they have to wrongly appeal ಅಲ್ಲಿ they have said that.
Yes.
ಯಾರನ್ನು ತೋರಿಸಿದ್ದಾರೆ? ಏನೋ ಹೇಳು.
Chief electoral.
Election Commission of India has not filed any appeal. ಏನು ತೋರಿಸ? Chief Electoral Officer ಅವರೇ ತಾನೆ.
They have showed it.
Easy.
He's not filed. Not filed. 11, serial number 7, Chief Electoral
Who is
Officer.
he?
Election Commission.
He is Sharat Chandra.
Yes,
In fact, not in the, I do not know whether it is by mistake. They have filed an appeal on behalf of Election Commission of India, saying Chief Electoral Officer as an appellant when there is no authorization also. Appellant number 7 is shown as Chief Electoral Officer.
Deputy Commissioner returning officer.
No, 7.
Election Commission of India. How do you represent?
Respondent number 17 is appellant. 7.
Appellant number 7. They have shown somebody as an appellant when he is appearing for the respondent.
No, my lord. What happens, my lord? Chief Electoral Officer, appellant number 7 is the state head. Respondent number 11, my lord, Chief Election Commissioner sits at the Delhi.
Your party number, respond number.
My lord, respondent number 11, my lord,
11.
Election Commission.
We'll file our
In
synopsis
fact,
in the process, my thing.
the writ petition, Lordship sees now the writ petition itself was filed by Dreams of Fountain Private Limited Company. The tender was in favor of DAP Hombale Limited. Then they say it has changed itself to Chilume.
That is
Then
because
finally Dreams of Fountain. So the money now that is to be paid is to the Dreams of Fountain.
registrar,
not even the
change
bidder.
of name is there not, we'll file all those documents.
Already.
It is filed also.
And they have been blacklisted. They were
I'm
found
sorry.
collecting
No, we are
the
not-
sensitive
Money or the money, election expenditure is from election.
from the, yes,
No, my lord,
Commission of
election.
India.
Then how?
I'm sorry, my lord, money, we will request the state government to release the money. Money is basically from the state government has to release money, even for the parliamentary election or assembly elections. Lord, first the parliament, the government releases the money. Thereafter, my lord, now it's the additional amount. We now if anything happens, my lord, we also request, we have to request the state government. We do not have the independent fund. We are all dependent on the state government.
It is accounted for in the account of election in India.
Yes,
Yes,
CFI,
ma'am.
it comes. Consolidated Fund of India, it comes. It is not even
State.
can't be. These are elections, I am aware of it. I used to appear for them, but Consolidated Fund of India, it comes from CFI.
So it is not the state fund which you.
No,
are
it's a
expecting.
sovereign fund because they did not
Stand
want to
corrected on
depend
that.
upon the state.
I stand corrected on that.
So give both of you the source of.
Yes. No,
Need
this-
be, we'll hear further, otherwise.
We'll file the synopsis.
May I
Summary of
just
submission.
quickly take through the judgments, just one, the compilation, the first,
Compile it.
which we just passed it on, the
Yes.
the very first
Any,
one.
any judgment, any pleading you want to do, you are welcome to supplement. Yes.
No, Lord, just the second judgment is of your lordships in BBP Studios case, Lord.
Which one?
The first page, my lord, is only one page.
That is,
Supreme Court,
that
no?
studio, that all judgments are.
BBP, your lordship itself has held serious contractual disputes cannot be adjudicated. There also matters pertaining to the payment of 4 crores. And the first decision, my lord, para 3, we fail to appreciate how the writ petition before the learned single judge could have been entertained for recovery of money alleged to have been due and payable under the invoice, under the bills and invoices. Learned single judge as such ought not to have entertained the writ petition under 226 for recovery of money under the bills invoice, more particularly so and so. So therefore, my lord, and reading the last para of the last judgment, which I just said, my lord, it is domain when we do an audit, my lord, there are accountants who are involved in looking into the bills. 348 invoices cannot be endorsed as correct. Now, Lordship may kindly see, that's the word that the learned single judge has used with great respect, my lord, has endorsed these 3 invoices by stating, I'll just read, my lord, in the considered view of this court, there is no disputed question of fact as invoices and amounts claimed are clear. That is, your lordship will find it at page 54, my lord. At page 54, my lord, of the impugned order. 6th line. Volume 1, page 54, my lord.
Yes.
The issue now, second line I'll read, my lord. The issue now would be whether this court would enter into issue of directing payment to be made to the or petitioner has to be relegated to fight a battle before the civil court. The species of submission of the learned additional advocate general is that these are disputed questions of fact. In the considered view of this court, there is no disputed question of fact, as invoices and amounts claimed are clear. So, virtual seal of the court on the 348 invoices and the amounts, which in my respectful submission, my lord, cannot be done in 226 proceedings.
Yes. Signed every document. Lord Lordships may kindly continue to read there itself. Deputy Commissioner first respondent pursuant to the proceedings and signed every document in terms of the proceedings dated 13/12/2019 and cannot now go back in time and contend that the petitioner has not put this side up. But ultimately, Lordships may have to decide whether this formula of a dispute has been used by the state only in order to shield non-payment, or there is a serious disputed question of fact. Ultimately, Lordships may have to pin down on that. If there is a disputed question of fact, well, Lordships may have to ask us to go to civil. But Lords, when at this length of time, when everything is certified, particularly the nature of consumption of food, would it be a matter, Lord, where
just not food, my lord, even cameras which have been erected, and shamianas, chairs, tables.
My learned friend said that there are 49 people working. The food has been supplied for 250 people. That is how, Lord, the dispute has been. We'll file our synopsis and summary of submissions.
When you will file? 7th?
Please.
7th, yes.
7th November.
Grateful.
That contempt is connected, it may go along. So whatever is the order.
Same.
Seal number 15 urgent, seal number 16. Udita Ramel.
Lord, this appeal arises out of an order passed under the Village Officers Abolition Act. My lord, I had the father-in-law of the appellant and one more person had made an application in 1973 for grant of certain lands under the Village Officers Abolition Act. The grant in my favor was not granted, so it was kept aside. If your lordship sees page 51, that is the initial order. At page 58, page 51 at page 58, about 8 lines from the top. In these circumstances, Ramanna, that is my predecessor, and Nanjundappa became equal shares of the hak and privilege and usufructs attached to the office of Shanbogi service. Shri Ramanna has not cared to credit the occupancy price of the lands and claimed His claim is passed over and rejecting half share. The following service in arm's length are granted to Nanjundappa. So nothing was granted to him. This state of affairs went on till, please come to page 156. '51, 150, 136, sorry, 136. Various proceedings took place at 136. It came up before this court. But there, if your lordship comes to page number 143, paragraph 6. The submission of learned counsel transcript, as long as the petitioners, I was the petitioner, long as the petitioners do not impinge upon the rights of the third respondent over 6 acres, 30.5 guntas from out of 14 acres, respondent cannot question the legality or validity of the regrant of the balance extent of land in favor of the petitioners. This was the land in 73 which was not granted to me. They said I had not paid the price and they had kept it aside. Narayanappa was granted. In these circumstances, petitioners having accepted to confine their claim for regrant in terms of the order dated 21/11/73, nothing further survived for consideration in this petition, accordingly disposed of. Weeks time for the petitioners to file necessary affidavit in that regard. Tahsildar is directed to proceed and pass orders on the claim of the petitioners in the matter of divesting the land from the government and vesting the same in the petitioners in accordance with the regrant by order dated so and so, 21/11/73. If the petitioners make payment of occupancy, they've already done compliance in 6 months. They still don't do anything. Then I file a writ petition, page 145. Next page, a writ petition. Next page, writ petition. So and so learned counsel for the petition submit the petitioner's grievance is inaction shown by respondent number 2 in considering the petitioner's representation. So and so appearing for the respondent submits that the petitioner's representative be considered in accordance with law. Recording her submission, I dispose of this petition to consider the petitioner's said representation in accordance with law as expeditiously as follows, so and so. My lord, now the learned now what happens in the meanwhile? 86 and 89, there appear to be 2 agreements of sale between Ramanna and the 6th respondent. Then there is a sale deed subsequently. My lord, the learned single judge, then what happens, my lord, in 78, Section 7 capital A of the Village Officers Abolition Act is introduced, which puts an embargo on transfer. 7 capital A, Lordship, I pass on that. Village Officers Abolition Act, 7 capital A, which came into force on 7/8/1978. I just passed this on. I'll book it. My lord, the learned single judge says that no, your grant has been made in 1973. Therefore, this order relates back. The sale deed 2014 is a sale deed. It relates back to 1973. Therefore, it is not hit by 7A. The doctrine of relating back may not be properly applicable in this case. The reason is there is no grant even as on 2015. This court says take necessary steps. They don't take steps. I move this court again. They said we'll take steps in 2 months. They still don't take. Then the Tahsildar transfers the kata in the name of respondent number 6. The learned single judge says this, my lord. Please see page 28. My lord, please see, this is the only problem. This is the problem where it arises. Page 28, para 10. On careful examination of the order dated 1st August 2013, passed in WP so-and-so, would indicate that this court has held that the land in question has been re-granted in favor of Ramanna. That is not the purport of the order at page 136. It only said, now that there's nothing else left, you take action. It did not re-grant the land in favor of Ramanna. If Lord.
No, what was the suit number 312 of 2004?
Yes, my lord. See, the Srinivas files a suit. In that there is a decree. In this there's a sale deed in favor of Srinivas in 2014. Well, what happens? No, this all I'm saying. What happens is, my lord, The grant in my favor is done, not done even on 2015. Please see, now the learned, this is where the mistake comes. The learned single judge says that there is a re-grant by virtue of the order of the learned single judge at page 136, which is not the case. That is all the point. If your lordship sees that order, it merely directs the Tahsildar to take steps to grant me. Tahsildar does not do so, I come back to this court again. Please see 136.
Where is the order of the regional authority? Page?
Pardon?
Deputy Commissioner's order, where is that?
160, my lord. 160.
160.
Here the deputy commissioner says, he applies Bashir Ahmed's case, saying that if there is a re-grant, he is entitled to the benefit of that period. Bashir Ahmed's case is up to 1978, introduction of Cap 7 capital A. If there is a sale before that, any re-grant before that period will be applicable. Here the sale is on 2014. My re-grant has not happened even in 2015. In which case 7A was applicable, there's a 15-year bar. The learned single judge applies the doctrine of relating back, which may not be correct.
That said lead become final.
It has become final.
Case and become final.
Yes, that's the only question, lords. Lords, that's the only question. Now, there is a decree.
May I make
Lords,
a
after the decree, the execution proceedings were filed.
What is the decree?
Decree for specific performance. In the specific performance decree.
It has nothing to do with the grant or re-grant.
Absolutely nothing to do, my lords. Now, I just mentioned this. After that, the present appellants were implemented as the legal representatives of Ramanna. The present appellants are the LRs of Ramanna. They were brought on record, my lords, as the legal representatives of Ramanna in the execution proceedings. My lords, then the court executes the sale deed for and on behalf of the present appellants in favor of the sixth respondent. Pursuant to the sale deed, the mutation is made. What is under challenge before the learned single judge is only a mutation made pursuant to the sale deed executed in my favor. And the learned single judge observes that the liberty is reserved, my lords. If your lords were to see, my lords, at paragraph number 11, page 29, he is already filed another civil suit challenging the sale deed.
One submission.
Which is OS number 1541 of 2019. Page 29, my lords.
1541.
1541 of 2019. He's already filed a civil suit by the present appellants
for
challenging the sale deed executed in my favor. That the learned single judge says you can agitate your rights in the pending suit.
One submission.
Nextly, it is to be noted that the suit filed by the petitioner herein in OS number 1541 of 2014 before the competent civil court is pending consideration between the petitioner and the respondents 5 and 6, and they have to work out the remedy with regard to their share in the property left out by deceased Ramanna. That liberty is fully reserved, my lords.
Just one submission. Section 7, capital A of the Village Officers Abolition Act says there's a 15-year bar from the date of grant. They assume that the date of grant is 73. The sale deed may be there. The sale deed cannot override the provisions of 7 capital A. Whatever may be the sale deed cannot override 7 capital A unless they can show that the sale deed is subsequent to the date of grant. There is no date of grant here.
All those questions can't be gone. Find a civil suit there, he can agitate all these rights.
Or learned senior advocate Mr. So-and-so with learned advocate Mr. So-and-so for the appellant and learned senior advocate Mr. Ravi Shankar.
Lordships.
For respondent, assisted by learned advocate so-and-so, so-and-so, as well as learned additional government advocate Mr. So-and-so, so-and-so, for respondent 4. 1 to 4, comma at length. The honorable party stated that they argued the appeal finally. They further stated that the pleadings are complete and no further are required to be added or supplemented, reserved for orders.
Great.
My lord, I have a small submission, Your Honor. My respondent is suffering with post-retirement. Lost his pension and medical. Wife is a severe cancer patient. Kindly accommodate here in the afternoon. I need only 10 minutes time, Your Honor. Please.
When it is listed today,
My list is 135 that today. It may not reach. Serial number 1, last in the list today.
we'll consider after recess. What can?
Lordships kindly,
Much
my lord,
obliged.
serial number 54, CCC, it is complied with. My learned friend is there. I will file a memo to that effect.
What is order is completed.
Please, my lord.
The honorable party stated that the order under contempt is completed.
Contempt, please.
They submit a memo dated so and so in that regard, which is taken on the record. The contempt does
I'm
not
sorry, my
serve
lord, I stopped.
any of the compliance and stands disposed.
Wait, wait, wait.
Lordships, serial number 16 matter reserved. Matter is reserved for judgment, serial number 16, my lords. In that, today, my lords, the matter,
16.
no. Notice may be dispensed for respondent number 5, my lords. In writ court, he is served unrepresented.
Which matter?
Respondent number 6 is the caveator. Respondent number 5, notice may be dispensed with, my lords.
Reserve. So. Senior advocate. What do you want about that?
The notice may be dispensed with, my lords. The notice may be dispensed with respect to respondent number 5, because he is unserved and unrepresented in the served and unrepresented in the writ petition court.
Number 5 did not appear.
Did not appear.
Should have pointed out. Then how can we resolve it?
Represented before seeking dispensation.
You are for appellant.
I'm for the appellant.
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 Let write down, give to some, so already taken the order. Before that order, before the order reserved, learned advocate for the appellant. Mr. So-and-so, senior advocate appellant, Mr. So-and-so, so-and-so. Seeks permission to delete.
Dispensed, my lords. Notice may be dispensed.
That can't be done. If you're deleting, then we'll delete. So then what is wrong if we serve, not serve?
The notice is not issued, my lords. The matter has come up for the first time. Fresh matter. So, my lords. The notice to the respondent number 5 may be dispensed with, my lords. Yes, madam. Much appreciated.
Serial number 132, madam. Serial number 132 minutes. There is a 30-day delay. So we will file the condonation of delay. In the counter, there is, since parties were not facing financial problems, and secondly, there is one IA which we have put for dispensation of the certified copies exemption. So that may be considered as not pressed. We will file that application and it may be considered as of today minutes, because their possession of the property, they are going to take the bank. That is the reason, minutes. Finally, it may be taken at the end of the list, minutes, since there is extreme urgency and parties are also present before this honorable hearing. Minutes. We have already removed the office objections and made a submission before this court.
My lords, serial number 45, it's coming up for non-compliance of filing of compliance affidavit by the respondent. I appear for the complainant. It's a contempt matter. My lords, previously also, several times they've been given opportunity to file the compliance affidavit. Amount of 1.5 crores is withheld. Now, the complainants are facing financial constraints because of the bill not being released in their favor. Kindly, my lords, I'm not sure if it will reach today, so may I have it next week at least, please?
Because today they are going for auction, the legal matter. They are going for auction of the said scheduled property in the case of surface matter. Minutes we have compared with all of the subjections minutes. This is we have also made a council submission seeking for an urgency also. Minutes we have also made a council submission in the office, this one also, that today there is an urgency in this to take up the.
We remove the office of person. After removing it, urgency file memo.
Number 136, 136. Nayana.
Has been granted 4 quarrying leases and 2 stone crusher licenses, which is the operative. All of a sudden, an interloper files a complaint before what is known as a Legislative Council Petition Committee. The complaint, the complaint petition under the before the Legislative Council Petition Committee. There is under the rules of the Legislative Council, they have something known as a petition committee. A complaint comes to be filed on 12/1/23, which your lordships would kindly come to 156(7). The Kannada version is at 155. The translated version is at 157. Third party gives a complaint saying that my quarrying operations are illegal, my stone crushing operations are illegal. Now that itself could not have been entertained because of the rules of the committee, which says in case there is an alternate remedy, that is, if there is an authority, there is a remedy. Lords, if I have carried out any illegal quarrying or mining, under the KMMC rules, there is a power to the Director of Mines and Geology, complaint can be given. Revisional powers are there. Be that as it may, he gives it. Based on that, my lords, pre-inspections are directed by the committee. The committee, my lords, directs the departments to conduct based on this complaint. I am not given the opportunity before the committee. There is no such thing. Now, 3 times inspections are done. 4th inspection, latest. All the inspections, the authorities direct, they find out a joint inspection that all the clearances are in order. The quarrying operations are in order. Stone crushing operations are in order. In spite of it, the petition committee directs the Director of Mines and Geology to stop the entire stone crushing and quarrying operations. Based on that, a letter is issued to me saying stop the entire operations. That is what I have challenged before my lord. Annexure Q at page 376. And the reports I will just show, my lord, I will not even take. The first report was on 11/7/2023. Second inspection report on 20th of June 24. Third inspection report 1st of August 24. 4th inspection report in September 24. In spite of it, my lords, because a petition committee directs stoppage of quarrying operations. And there is no such power to the petition committee with great respect. The petition committee is headed by a chairman who is a member of Legislative Council. And this complaint, which has no. My lords, please come to annexure Q at page 376, my lords. The director has narrated that. 376 is the English version, my lords, issued by the senior geologist.
In that reference number 1, if your lordship see, 376, annexure Q. Lord, there are two survey numbers. In 180, my lords, I have quarrying leases. In 167, I have stone crushers. Annexure Q and Q1 are there.
Then 188 is for what?
Yes, my lord. My lords, the complaint, that is a complaint filed by the complainant. 188, survey number 188. Sorry, it is 188 in the Kannada version, it's 188. I'm sorry, English version. Kannada version is at 155. I'm sorry. Based on this, please see the stoppage order issued at page 376. This complaint is a general complaint by an interview. After this was issued, they conducted an inspection and a report was submitted on 11/7/23, the first report, which is at 269. (269) is the first joint inspection report. Again, lords, 4 reports are there. 4 reports, and the 5th report also, my lords, we have filed along with the memo with additional document of the latest report. Again, they say there is no. Lords, closure order can be, my lords, be issued by the senior geologist or the director, but he refers to the committee's direction, which is not given to me. If your lordship comes to the impugned stoppage notice at annexure Q, page 376, he says committee has directed. Yes. They have no, my lords, if you I'll just pass the rules, my lords, the committee petition rules. The senior geologist who issues. We do not, because they don't, my lord, they don't issue notice to me. I am not heard, I am not given any opportunity before the committee. They direct the department. They direct the department, my lords, to conduct the inspections. 4 times, department, along with everyone, have conducted inspection. They find there is nothing wrong. In spite of it, they say committee has directed. My lord, 376. Last, as directed by the petition committee of the Honorable Legislative. 7, yes. Therefore, as per direction, that's said, your lordships. Let 377. Reference. (13/8/24), head office direction. That's the director of mines and geology. As per the direction of a committee on petitions of the legislature. With immediate effect, hereby directed to conduct a joint survey and submit a report on the same until further orders to suspend all mining leases so-and-so and stone crusher granted in your favor. Prior to this is dated 13/8/24. So prior to that, my lords, please see, there are 4 reports. Director's letter is not on record. But notice was issued. Now I have stopped everything. And if your lordship just sees the rules, my lords, the petition committee does not even get direction, jurisdiction on this. If the legislative council rules, if your lordship sees, it's very clear. May I just pass on that extract of this. Otherwise, my lords, everyone will just go to a petition committee, file one innocuous half a page complaint. Somebody who is not interested in my operations. And in spite of 4 surveys, the latest survey also is there.
My lord, may I make one submission?
And it is settled position today, my lord, that committee has no powers of adjudication. It's a judicial.
My lord, pursuant to this, there was an survey conducted on 20th September 2024. My lord, in respect of quarrying lease number 439, my lord, it was found that they had quarried outside the leased area to an extent of 1 acre. My lord, I have the spot marker, English translation. Yes.
Used it, that is in 2015.
No, 20th September
Survey
2024.
is done, my lord. They say penalty is paid. Please see the report. They say in 2015, there was an encroachment penalty paid.
No, sir. That is not it. This is what I am producing.
So the reports, my lord, just please see the earlier reports from the petition committee after that. Please come to the first report, my lord. Annexure 3, page 269 for a moment. This is a joint inspection done on 11/7/2023. 269 minutes. In that, please turn over to 272. At 272, after the chart, second one. Stone mining contract, fine of 74,65,000 was imposed on 15/10/2015. Four leaf and 2 stone crushers. All are stopped. My entire operation has come to a standstill today. My lord, I have employees, I have expenses. And
My
please see
lord,
the-
I'll just produce the spot master, my lord. It was conducted on 20th September 2024 at 11 a.m. My lord may see this paragraph 2.
Already on record.
No.
The jurisdiction.
Yeah, that is. Yes, yes. Yes, ma'am.
Please, my lord, we may just give. Just see the rules, my lord, of the petition committee rules.
Sir, can I have a copy?
Yeah. Please come to running payment standards. Please. Page 6, if your lordship comes, it contains annexure.
Give it back to me.
Rule 133, scope of petitions, your lordship should get. Not in that, it's internal page 6 of that
It's the text of
The
it
heading
doesn't have.
annexure. And the 133 rule, my lords, talks about the scope of petitions in before the legislative council petition committee. And in that 133 clause 3A and C, if your lordship sees, it says which petition cannot be entertained. Please see me. Just read the 133 clause 3A, my lords. Any matter of general public interest, provided that is not one which falls within cognizance of a court of law having jurisdiction in any part of India, or a court of inquiry, or a statutory tribunal, or an authority, or a quasi-judicial body, or a commission. Then C, clause C, for which remedy is available under the law, including rules, regulations, bylaws made by the state government, or an authority to whom power to make such rules, regulations is delegated. So they can't even entertain this because the KMMC rules govern the entire field. Yes, ma'am. 1993 rules, which is amended. It's originally 90. Now this, otherwise everyone will go before a petition committee and file one innocuous petition, where the leaseholder has no right to appear there.
Dual number so strong. Don't pressure stuff. Yes.
What about taking action?
and the stone crusher also.
My lord, in respect of one quarrying license, they have quarried outside the area. If my lord could reserve us the liberty also, my lord. Very well. My lord, could I have a hand delivery, my lord, so that I could- hand delivery of this order so that immediately I can get. Obligement. Obligement. My lord, notices have been issued on 24th September. Inform your director.
1, 4, 5, 6, 7 they can take.
Obligement.
Remember 137, Lem Chidanandaya.
It's the covered matter which I had last occasion discussed, your lordships, at page number 6. Para 6 of the order, your lordships. 5.1 says that the earlier order has been challenged in the Supreme Court. It said that in terms of that once iron ore mineral is transported with Form 27, there would be no necessity to obtain Form 29 for transportation, and Rule 145 of Karnataka Forest Rules does not empower the forest officials to insist to obtain Form 29. The order dated 1/2/2021 by the Supreme Court is aforesaid. Special leave to the appeal figures on record. The order expressly states that no interim order has been passed. Therefore, the mere pendency of the special leave petition will not be a good ground to deny the relief to the petitioner when law laid down in the supra holds the field. Yes, Your Lordship.
Yes,
Same.
obligement.
Much obliged.
This for withdrawal of petition, appeals. Number 138, Mr. Sandeep CT. Mr. Sandeep. Number 139, Mr. Bhargav D. Bhatt. The Bhargav D. Bhatt. The number 140, the Ganpati Bhatt.
We filed a withdrawal.
This is number 141, Mr. P. N. Nanja Reddy. Number 141.
Be permitted to file the compliance affidavit. My lords. My compliance affidavit, my lords, with the translated copies.
Number 142, State Appeal.
My lords, in this case, my lords, writ petitioners had filed a memo for withdrawal. State
Withdrawing
had
the-
filed an
Withdrawing the
writ
writ petition
petition.
itself, my lord, your lordship, the turf club man.
My lords, directed us to file the withdrawal in the writ appeal. We have filed withdrawal with liberty to leaving all contentions open. Respondent number 1, original writ petitioner. Arihant. Arihant. Please, ma'am. Please, please, ma'am.
Only appeals. Impugned order, no?
Yes.
Page 38. You're withdrawing order. My lord, against an interim, the learned single judge by an interim order permitted the running of the race, my lords. 18 June 2024. There are 5 writ petitions, that is WP number 13503. All the writ petitions, 6 writ petitions, my lord. Page
Common appeal.
38, court officer.
Please, my lord. My lords, I appear in one of the writ petitions, the main writ petition of the club. So it is a common appeal against all the,
Case number, court is asking.
it is a common against the, it is a common appeal filed against all the,
The writ petition. What's your writ petition number?
135 is my number. Please. My lordship's made 13503, the main appeal, writ petition is us. please. My lords, we can only appear for our petition. The other persons,
What your lordship, in fact, the other day, my lord, the other appellants were respondents who were the petitioner were present, my lord. They made a submission that they'll come today and withdraw the case. They are not present today before the court. Other petitioners were present before the court on the last date, my lord.
writ petition 13503 of 2024. That's
That
the
is
main
the-
case.
That is the Bangalore Turf
Filed by the
Club Limited.
Filed by the club. This is the main case. They're all the
Can I make one suggestion, my lord?
That's by liberty, leaving all contentions open. We have requested liberty. Yes.
Please, my lord.
That's with liberty,
Please, that would,
with liberty that we sought for. Liberty to file a fresh petition if need arises.
that
That
is
may be
always
reserved.
there, my lord.
Because the prayers that we have sought is wide, so that liberty may kindly be reserved.
Court of- Lordship may tag it along with this, my lord, so that it. Or your lord. No, please, that, please.
My lords, liberty may kindly be reserved. To file a fresh petition if need arises, because we have asked for various prayers. Please, my lord. Well, there's a declaration we have asked for, so that may be kindly be reserved. That's because the government has considered our request and granted. No, because of the declaratory reliefs, that's why I'm asking for that.
Still number 143, Mr. G.R. Mohan.
Appear for the.
Lordship, in this matter, regarding redevelopment of Gandhi Bazaar Main Road, earlier which was a heritage place. Then subsequently, the fourth respondent has redesigned under the redevelopment project. Based on that, your lordship may kindly see, by virtue of that, the parking and other things are all become haphazard basically now. Earlier, there was no problem regarding parking of vehicles and movement of vehicles. Now it is a total traffic hazard. The photographs which I produced along with additional affidavit, your Lordship, kindly look it for a moment. Page number 143. The additional affidavit filed on 18th January 24, your Lordship, for a moment. January 24, your Lordship. In that page 139 onwards, your Lordship. Additional affidavit filed by the petitioner on 18 January 24, page number 139 onwards. Because the why I am saying this, the traffic police also issued an endorsement. How the problem is there now with the traffic. Because basically I am not mainly only concerned on regarding the reduction of width of additional affidavit, your Lordship. The photographs. Page 139 onwards, your Lordship. One. 139, you like, page 139. The earlier, how the vehicle used to be parked before redevelopment, 139 page annexure Z1, you like. Then you will kindly see 140 and also how it was there. Then 141, buses were running, page 141, you like. Bus route was there. About they themselves have stated in their project plan, 62 bus routes were there. Now, by virtue of the redevelopment, no buses can fly. See, one part, then you will kindly see page 142 or 142 annexure Z. How the vehicle has been parked and under the haphazardly it has been parked. Then also 143, the shops have come up. Then transformer is put on the footpath in front of a bank on the ground floor, on the ground level itself. Because normally transfer all usually be put on the pedestal, actually, single polar. Then 144, you will achieve. Steel frames have been put up in between. Then the endorsement given by the police, your Lordship, traffic department, page 145, annexure Z, translation at 147, your Lordship. 147. In that, your Lordship may kindly see for a moment. Have not obtained any permission from the buzzer which your Lordship got 148, your Lordship, translation copy. 145 is the Kannada version under RTI which has given reply. The last document, your Lordship, in that affidavit. In fact, they are not even given permission to continue with the work. Actually, that is what the endorsement given as per which is at page number 147, your Lordship. The law. I have not obtained any permission from Basel on the executive engineer project so building another traffic and to office of the higher officers have submitted application for grant of. Even though the BBP officers were asked to give an undertaking, letter have not given any undertaking and hence to the said work not to give any permission, report is submitted to the higher officers. Then that's the reason by virtue of this, Lordship, I filed a year number 2 to impeach the Joint Commissioner of Police so that he will be the better person because we are all not experts. So how to manage traffic? Only we are concerned about the traffic because of the reduction of the width of earlier it was 45 feet, your Lordship. Now the width of the, I know, your Lordship, the court cannot go into the whether the road, how it should be or not. I'm not on that. I am only concerned about traffic, pedestrian safety, because pedestrian has to come to the road actually by walking, because all the vendors have been put up as per the photograph, which is a hazard. That is also not permitted by the authorities. Till date, there was no vending zone earmarked or survey has been conducted under the Street Vendors Regulation 2020. That also I produced in this affidavit, your Lordship. Along with that. So my only response as far as IA2 is concerned, Lordship, let the government take notice for Joint Commissioner of Police. He can submit a report. Based on that, this writ petition itself can be disposed of. I'm only concerned on that. Because because ambulance cannot pass through, fire engine cannot pass through in that road, and buses cannot fly now. There were bus route was there. And it was one of the oldest locality in Bangalore. And most of the temples, all are situated in one place where it's a heritage issue is involved basically.
My lord, we filed, my lord, on 1st of August 2024. We have filed the statement of objections. 1st August 2024. My lord, we have spent 24 crores remodeling this road. We have taken,
My lord, from 24, my lord, it is in operation. January 24, the road was completed. The particular road which my learned friend is saying, my lord.
the road is thrown open.
No, they are using the road, my lord, public is using and the pedestrians, my lord, there's no. My lord, under the Hawkers Act, my lord, we had to provide them certain shelters. That has also been provided with, my learned friend has produced those photographs also. Oblige me. I'll, 2 weeks.
In fact, the Sabha court in February asked me to give the sketch along with the written notes.
Yes.
My
In
lord,
fact,
they want the road to be remodeled and redesigned again after spending 24 crores, my lord.
4 crores has been spent on the road.
They gave us suggestions. There are no grievances from the public.
In fact, my lord, for the Bangalore city, it's one of the best roads now.
No, earlier it was 45 feet width was there.
He filed an
Normally,
application
your
yesterday,
lordship
my lord, it has
may
come
pass
up.
on the judgment of your lordship in earlier matter, where this court, based on even the direction of Supreme Court and this put in another writ petition, how the traffic, to solve the traffic problem, pass the public, it should be widened. In fact, that's what may pass on this judgment.
If they
lordship's
give us
order.
25 crores, we will remodel it, my lord.
May pass on this. Because they have produced a judgment of your lordship earlier.
It's
But
covered by my
actually,
lord's
this judgment is particularly really how the traffic problem solution should be solved. That's the only thing. So let the government take the assistance of Joint Commissioner of Police because he is the expert person, and along with there are experts with opinions also I furnished to them. Just one Mr. Srihari, who is the traffic management expert. So he has given his input in this. Also, I filed it in the additional affidavit, basically. So it can be examined only on that point. I am not on, because the government already says that road has been, I am not on that. How they are going to solve the traffic, that is my concern. Because
That is
people
not-
cannot, because pedestrians have to come to the road because it is all blocked by the vendors now. Steel frames, everything has been put. It's very difficult. Please. May pass on the judgment because they have produced on judgment, may pass on this permit me to.
My lord's judgment, my lord, my lord's judgment which is covered.
Para 3, Your Lordship, the concern owner, bottleneck, same thing is a bottleneck it was. Please. Yes. That any, the 230, Your Lordship, it can be 230 list, Your Lordship.
No, the
230 last occasion it was ordered. That, please. Okay.
So when?
The date, my lord.
Anything. Convenient date. Please.
This is number 144.
Appear for the spot.
So this is good for the day.
Maintainability on objection. How take care of?
Happy for the appellant. They pass over the matter, my lord. The appellant has engaged with the services of a senior counsel. He is arguing a matter in court on number 16, my lord. Few minutes, my lord. Will be.
Suit is specific performance, Lord. Suit is for specific performance by a company which is not in existence at all. The company appeal itself is not maintainable, Lord. Last time, what is the request matter is posted?
6th of November. 6th of November. Any day as my lord pleases. 6th of November. 6th of November. Interim order, undertaken. Undertaking is there the same maybe. There is an undertaking regarding alienation of the property.
That undertaking cannot, last time also.
Misusing the.
He is not arguing the matter.
From last,
and,
from the date of filing of the suit, it was there, an order itself
Suit-
was there.
Appeal itself is not maintainable.
Another 6
He
days
is-
would not make much difference, my lord.
This company is not in existence. I don't know who has authorized him to file an appeal.
Pasora made also. Any day as my lords pleases.
230, Mullah.
230.
Because the only point is, Lord, without going into merits, the maintainability has to be examined.
That will be convinced, my lords. We'll convince them.
The only thing is he's taking time without.
Not no, my lord, senior counsel. Not no, my lord.
Date.
Date.
Number 17. Mr. Mohammed Samir.
Yes.
17.
I'm appearing for the appellant, this matter. This is, an appeal, what the
Plus, there is a delay of 39 days in serial number 17 and the 18, which is also connected matter.
plus
Delay may-
17 and 19, my lords. In
Both are-
17 and
Both writ appeals have been filed against the common order passed by the learned single judge. Delay may be condoned. With regard to stay and the production of additional documents, I may be given some time to file objection. Pardon?
Delay is condoned?
Yes, delay may be condoned.
No objection to condone.
Yes.
17.
And 19.
17 and 19 are, they're
19.
17. IA number
17 and
24, heard learned counsel for the respective parties, delay of 24 days, prayed to be condoned, 35 days is properly explained in the supporting affidavit. Therefore, sufficient cause is made out. Delay to the extent of 35 days is required to be condoned. It is condoned, application is allowed. Which is the other one?
Another is the serial number
item 19, my lords. Your
19.
lordships.
Same.
So 19 must same order,
Yes.
36 days delay. So when shall we keep the appeals?
Let's see, anytime next week time.
Can
Because
your
I'm-
lordships?
I may be given only a week's time to file objection.
Well, I have no issue, whatever time your lordships deem fit, my lords, for them to file their reply. Can your lordships hear me, my lords? I don't know whether I'm.
Yes, yes.
Yes. But whatever time your lordships deem fit for them to file their reply,
8th of November.
I'm obliged.
Cell number 18, Mr. Satish K.
Matter pertaining to Lord transfer. Lord, the private respondent was posted to the present place, Lord, on 36/20/22. Lord, he is in the cadre of Lord Assistant Executive Engineer. Lord, the minimum tenure prescribed in the transfer guidelines is Lord 2 years. He has completed the tenure. Lord, he has been posted within Bangalore, my lord, from one subdivision to another subdivision. Lord, the order dated 37/20/24 was challenged. Lord, the impugned order is at page 26, my lord. An interim order of stay is granted on the ground that, my lord, he is left with less than 1 year. My lord, he has been transferred within Bangalore from, my lord, Somanhalli to, my lord, E4 subdivision within Bangalore. And in his place, my lord, I have been transferred. But page 84 is the impugned order of transfer dated 37/20/24 before the, my lord, against the interim order, my lord, the present writ appeal. Not he having completed the tenure, my lord, he has no right to continue in the same place. And my lord, the retirement may not come in the way because.
This is interim order, we are not inclined. Heard learned advocate.
Lord, may I request this, my lord? Lord, let writ petition be decided, my lord, within an outer limit of, my lord, 2 weeks or, Lord, this interim order is granted on 2nd August 2024. Lord, instead of, may I request for, Lord, disposal within an outer limit of 2 weeks, my lord.
Appellant herein is original respond number 4. This appeal referred by the appellant is in respect of order dated the date of the order
2/8/2024, my lord.
2/8/2024, which is an interim order. Thereby the order of transferring the petitioner, original petition. Respondent hearing, respondent came to be stayed till the next date of hearing. The present appellant has been transferred at the post where the petitioner is working. Full stop. Since the order is interim order and the interim stay was granted only up to the next date of hearing. to be
Thereafter,
considered
my lord, interim order is continued from time to time, my lord, at
next date of hearing, comma, although it has continued thereafter, comma, the court is not inclined to entertain the writ appeal inasmuch as it is against the interim order which does not crystallize the rights of any of the parties finally. The extension or otherwise of the interim order
Stay.
of stay of the transfer is at large before learn a single judge. On merits. Paragraph, as the court is not inclined to entertain the present appeal on the aforesaid ground alone, from a learned advocate for the appellant, Mr. So and so would submit that the learned single judge may be required to dispose of the writ appeal itself at the earliest. First of the counsels appearing for the respondents, the senior counsel appearing for the respondent, Mr. Ravi Shankar, Mr. So and so, so and so, so and so. I have no objection to such request.
I
being
appear
made.
for the
No
respondent
objection.
corporation.
Such request being made by the
Yes.
appellant before learn a single judge.
Please.
It was stated that the parties shall cooperate, that the respondents respondents hearing shall cooperate. The hearing which may be fixed by learned single judge as per his own schedule.
Please.
Full stop. Expecting that the writ petition will be disposed of by learned single judge as early as possible with cooperation of parties, subject to the schedule of hearing of learned single judge. This appeal is not attended.
Great. Great.
but within an outer limit of within an outer limit of, my lord,
Preferably within 4 months.
4 weeks, my lord.
If he gets it listed, minutes, I'll assure my learned friend that I'll not take an adjournment. I'm always there. I'm always there.
Will not be good.
Yes,
Fix the timetable.
that's true, minutes. Grateful.
Transfer matter, my lord.
Pardon?
It's a transfer matter, very short matter, my lord.
Therefore,
Please,
if we say 4 months, you can get it disposed of in 4 days.
lordship,
You are challenging transfer.
but
They are challenging.
I am the respondent before the Lord Honorable Learned Single Judge, but I have been posted to his place. Your Lordship may say, my lord, as expeditiously as
As
possible.
expeditiously as possible.
Please, Vinod.
Obliged.
Agency number 21, Shrimati Sudhadi.
This was 18. 19 is at 20 is at.
Sir. The appellant in 1977.
Who appeared? Who?
Learned Standing Council for the Canara Bank. Mr. Muttanna is there in the CP Muttanna. Mr. CP Muttanna Learned Council for the Canara Bank, who appeared in the writ petition with Learned Singhal. If my lords are pleased to direct notice today, perhaps it can be heard. And before the Bombay High Court also, the criminal appeal is getting listed. Notice, please. Maybe a date be fixed,
This number 22,
please.
Sridhar Prabhu.
This matter, my lord,
Counsel by me.
the tender is, my lord, invited. I challenge the tender on multiple counts, my lord. One of the grounds, important grounds, is that, my lord, the tender is invited on the date of the model code of conduct invocation. May I persuade your lordships to see page 401, my lord. This is one major ground. Now, the contention taken is that, my lord, they have completed the work. There was an embargo, clear embargo, my lord, not to conduct any 401, if your lordships were to see. May I persuade your lordships to see, my lord, page 401, clause B, my lord. Clause B on 401, no work shall start. Yes, my lord. This is, my lord, the model code of conduct published by the Election Commission of India. Your lordships have it, my lord. It is in 401, my lord, clause B, no work shall start, lordships have it. No work shall start in respect of which the work orders have been issued before the issue of this letter, but work has actually not started in the field. These works can start only after the completion of the election process. Now, the contention taken is that 80% of the work is done. This is clearly in violation of Election Commission order. And the date of the tender is the date on which, my lord, the model code of conduct came. Clearly politically motivated, one. Second ground is, my lord, that the private respondent before your lordships submits a joint tender, whereas, my lord, this joint tendering is not permitted. May I persuade your lordships, page 109 for a moment, my lord. The tender is submitted.
We'll
The-
hear this finally.
Sorry, my lord.
We'll hear this finally.
Yes. Clearly, there is an embargo.
The base, only one submission. He was not the applicant in the tender also. He didn't
That I will explain.
participate
No, I will
also.
explain that. I will explain that.
Simply
The
troubling us with
electrical,
this
I am an
petition.
electrical contractor.
They are simply wasting time.
I'm submitting. Look, I was an
Just bringing
electrical
it as a public
contractor
interest
and
litigation,
your, I was an
unnecessarily troubling all
let
these
me
people.
complete, my lord. I
And
was an
the
electrical
work order
contractor.
issued-
Civil work was clubbed along with us.
In
Just to see
January-
that it is an electrical work, my lord. Electrical contractors were
Applicant.
barred and civil works were clubbed.
He's not an
And
applicant.
he is not an electrical contractor, not qualified to participate.
He is not
Kindly
applied.
see, my lord, the electrical contract work and civil contract work is clubbed. I am an electrical contractor. They say that I should be registered with PWD or some other work contract. And whereas, my lord, this person is not an electrical contractor, not authorized to conduct any. Lordships may see 106 for a moment, my lord. This is my primary contention. 106.
Lord, kindly
Lordships
ask
may
him
see
whether he-
construction of, I think he should
He has
allow me
not
to argue,
applied.
my lord. My case, page 106, construction of library building, shops, development, comprehensive development, bifurcation of works. Then your lordships will see improvement in median under flyover, providing street name boards, LED street lights and bus shelters. Now, this is an electrical work and electrical contractors are, my lord, alone competent under the Electricity Act and rules framed. But they club it and now see 110 for a moment, my lord. This is an electrical work and who are allowed to participate? 11033.33.1, my lord, tenderer shall be registered with BBMP, BDA, NHAI. So what they do is, my lord, electrical work tender is called and PWD contractors are made to participate. And composite tender, just to ensure that the electrical contractors who are undertaking the electrical work should be barred. And this is issued on the date on which, my lord, the Election Commission invokes the Code of Conduct. And secondly, your lordships may see, he is, my lord, he has surrendered his license. He is not a license holder. He surrenders the license in favor of a company and that company, my lord, and this individual collectively participate. as a joint tenderers. May I persuade your lordships to see the joint page 295 for a moment. Sorry, 297 for a moment. Your lordships may see, my lord, he has surrendered his license. This is to certify that, page 297 for a moment. This is the tender document he has submitted.
Your number.
No, he is both. He doesn't know. Ashfra is also, my lord, the tenderer. And this person is also, Abhijit is also the tenderer. And their documents collectively are submitted.
MD.
You are
No.
successful tender.
Lordships may see, my lord, this is to certify that Ashfra having registered office at so-and-so and Abhijit managing director, class 1 contractor, carrying works in so-and-so have executed several work contracts. Abhijit being the managing director has transferred all his works. Next paragraph. He has transferred. Lordships may see Abhijit A, being the managing director of Ashpra, has transferred all his works contract license in favor of Ashpra. Now, my lord, I ask myself, here is a license based on which, my lord, the tender is called. Page 294, the previous page. This person, my lord, claims to be the managing director. He is the license holder. He has already transferred. I question myself, my lord, how could he participate in the tender itself? And it's a single bid. Because the other tenderer has not submitted the tender, the turnover from 2018 onwards, my lord. The whole tender is a sham because first of all, my lord, electrical work is involved. No electrical contractor can participate because PWD contracts are called. And it is on the date of election, the model code of conduct, it is invoked. Thirdly, my lord, this person jointly with his company, my lord, it is settled proposition since hundreds of years. Company is a different individual than an individual. Sorry, man.
Since hundreds of years.
Yes, my lord, that since the Companies Act, the first proposition, my lord, on Palmer, the Companies Act says company is a different legal entity than an individual. So these, my lord, they combinedly, they pool their resources. As an individual, he has some work contract experience. Company has some work contract experience, clubbed and participated. And, my lord, a false submission is made that 80% of the work is done. Now, election code of conduct is, my lord, invoked. And election code of conduct, I read to your lordships, no work can be progressed. Now, in violation of code of conduct, they say they have done. Thirdly, my lord, there is a project monitoring contract separately issued in June. Unless the project monitoring contract, my lord, monitors the works, he cannot execute the work. The project monitoring agency's scope is to monitor the work. May I persuade your lordships to see, my lord, the statement is made that 60% of work is done, 70% of work is. Election was in vogue. The elections were in vogue. No contract could be undertaken. And also, my lord, Annexure W, your lordships may see, which clearly says, my lord, the 382, my lord. May I read it with your lordships? The 340, my lord, my apologies. 340, my apologies, my lord. Yes. Kindly see, my lord, the project monitoring scope. This is another tender called for monitoring of the work. 340, my lord. The main objective, am I reading with your lordships? 5.2. This is issued in June, my lord. 4th June. The main objective, 340, my lord. Clause number 5.2a. Reading with your lord. The main objective of hiring PMC is to see that all construction activities are executed by contractor as per the codal provision and drawings. For every activity, including testing of material at site, yard source is responsibility of PMC for all items of work. Further, PMC will have to monitor, manage, and document to see that required progress is achieved as per the program. Now, my lord, he has to approve the drawings. He has to approve the progress. He has to approve at every stage all works to be done. So till the PMC contract is executed, this PMC is not finalized. And PMC is, my lord, June 4th. He claims that 80% of the work is done, 60% of the work is done. If the PMC itself is not appointed, who is to monitor the work progress, how could he do that, my lord? And secondly, election code of conduct was there, my lord, where no work could be executed. So, my lord, a false submission is made before the honorable single judge that work is complete. So on that count alone, I am unsuited. All that I am asking is, my lord, whether the work could be undertaken in violation of the election code of conduct. Secondly, my lord, without the project monitoring agency itself being appointed on 4th June, whether at all he has done the work or he could have executed the work. Thirdly, my lord, whether a joint tender is possible. If an individual may claim that I am the same entity, I am the managing director, somebody may say I am a director, can those expertise be pulled? And particularly the awardee of the contract has transferred his license in favor of another entity. So therefore, my lord, in the surrounding circumstances, the entire issue is vitiated, the entire tender is vitiated, and more particularly, my lord, as I was submitting in the earlier phase, the electrical work cannot be undertaken by a non-electrical person because, my lord, the electrical rules say so, electrical act says so, electricity act says so. And therefore, my lord, a combined tender was issued, and this work was of a completely distinct nature. The scope of work was completely different. One was electrical and one was, my lord, regarding LED supply and installation. And finally, my lord, page 106, your lordships may kindly see. The scope of work, my lord, is completely distinct. Lordships may see, my lord, 106, which I was reading earlier. Your lordships may see, even for electrical work, it is second, improvements to median under BGS flyover and providing street name boards, LED street lights, etc. 106. See the qualification, my lord. As per the procurement portal, class 1 civil contract. For electrical work, they make a civil contract. Now, my lord, my learned friend comes and says, you are not qualified. Of course, I am qualified for electrical work, which is, my lord, one of the scopes in this. But if they combine it, this is, my lord, a very ingenious technique where electrical work is combined with civil work and civil work is combined with some other work. Nobody will qualify and PWD contractor will execute electrical work on the date of election announcement in the face of a, my lord, election, the code of conduct announcement. So all that I am praying is, my lord, let status quo be maintained and let this be examined, my lord, which is symptomatic of a larger disease. Where, my lord, on the date of election, these works are executed, and in violation of the election code of conduct, work is executed. An unqualified person clubs his expertise with some other entity. And secondly, my lord, the second contract, this is a single bid, because the other person who says, my lord, has participated, has not submitted his turnover from 2018 onwards. He's a dummy bidder. Suppose, my lord, only one bid is there, they could have straight away rejected. May I show to your lordships, from 2018 onwards, the other bidder has not, my lord, submitted any documents, 298. That person, he got his license itself in 2018, 2020 onwards. Whereas the requirement is 5 years license, the works have to be shown. If his license, the other bidder, if his license, my lord, is of 2020, it is a single bid. And single bid is, my lord, straight away in violation of the KTPP provisions. This is all, my lord, I have to submit.
First submission is regarding the attack made on the ground that the election code of conduct was in force. My learned friend pointed out from page number 401. Only one line he forgot to read. I would like to read that portion of the line. No work shall start is the what he read. I have been issued before the issue of this letter, but the work has actually not started in the field. These works can start only after the completion of the election process. However, if a work has already actually started, that can continue. Now kindly come to this line was not read by my learned friend. Kindly come to the page number 105, which is the tender. Tender was way back in 24/1/2024. This letter is on 16th March 2024.
An invitation for tender, not tender.
2024, January, the tender was called for. Work order was to be issued. That day itself, it is work order is issued. The process of tender has been completed. Now in the appeal, writ appeal, he is harping upon this one aspect. This is one aspect, saying that there is an election code of conduct, and for convenience sake, he reads only one portion of para B of page 401, giving up reading of, however, if a work has actually started, that can continue. When the letter itself, his own letter specifies that the work can continue, and it's from January that has been implemented.
Page 287
My
is the
second
work order.
submission is, no, please.
I'm
wait.
sorry, 280, I'm just factually correcting, Lord. 287 is the work order issued on 16/3. I'm sorry, I'm just the factual correction.
May I just complete my submissions, please? I didn't interfere when you argued. On 24/1/24, the tender has been called, page 105. It is not as if it was called on 16/4 and that has to be stopped. That would have been possibly it would be correct for my learned friend to contend that the tender itself and the other processes could not have been proceeded with in view of the fact that the election code of conduct is in force. I cannot say that it should be still going on because tender is issued. But the process of tender was called 3 months ago and the process of tender was completed. It is accepted, that is done. No, my lord, the basic case in this case is, from the time of this filing of this case, question was put to the other side, even in before the single judge. What locus standard do you have in this matter? Absolutely no locus standard. He is not an applicant also before the tender.
The work order is on
Request your
the same
lordship to
date as
kindly
the election.
reject the writ.
Please saying, Lord,
There is
status
no-
quo, I'm not, the work order is
We'll
on the
con-
same date,
We'll continue tomorrow.
afternoon session,
Tomorrow at 11.
Day after tomorrow. I am for the
afternoon
response.
session. Half of the arguments are come.
Tomorrow,
Yes, tomorrow,
afternoon.
2:30,
If I am,
2:30,
if I am permitted to make a submission.
2:30, my lord.
Morning,
No, I love,
2:30.
2:30, my lord. Great.
If I am permitted to make submission, serial number 83, writ appeal. I am facing a contempt proceedings. They have filed contempt proceedings. Learned single judge has directed the corporation to pay the compensation in respect of which there was no acquisition of the land. There was no acquisition of the land. Learned single judge has directed the corporation to pay the compensation. I am seeking for an interim order. Now they are required to comply with the office objection that they are not doing. I sent a letter also requesting, please comply the office objection so that the matter could be disposed of or heard by the bench. They neither comply with the office objection nor they are cooperating with the
Contempt is coming up. Contempt is coming up when?
date is not given.
We'll take up.
Date is not given. In fact, they have filed, we have entered appearance, we have filed statement of objection stating that we have filed the writ appeal before the division bench. It is in the warning list.
To be listed with contempt petition number.
It is in the warning list matter is
To be listed with contempt petition number. Which contempt?
1055 of 2022.
1055/2022.
Please.
My lord, sir, serial number 70, my lord, sir.
30. Number 30. your
Yes, your matter is not reached. Tomorrow. Tomorrow at 2:30.
My lord, sir.
Number 30. your lord.
May I have the liberty to mention a matter?
Number 88, your lordship. Your lordship, writ petition has been challenged and the matter has been posted before the single judge and the matter is on Friday, your lordship. So the
What?
date,
Friday is Friday.
Friday 25th, your lordship. So
Right.
a date before that or on Friday may be convenient,
Why?
your lordship.
Why before Friday?
Your lordship, we have challenged the orders of writ petition and the matter is on this Friday, that is 25th, your lordship.
Which matter is on Friday?
The writ appeal, your lordship.
Very good, we'll take up on Friday. It is on
May
Friday.
I?
Your lordship, the matter is the matter that we have challenged is on that is your lordship, we have challenged the writ petition, the orders of writ petition and
Serial number mentioned.
And writ petition is coming up on Friday.
no, your lordship.
So what is coming up on Friday?
May I submit your lordship?
To find out till when you were mentioned, last we'll take up your.
My lord, sir.
No, 30, your lordship. Serial number
Yes,
30.
may I have?
The execution is levied. I am pressing for an interim order. Matter may be taken up on Monday, kindly. Because in the trial court, execution is coming up on the 2nd. Sorry.
You can seek time there.
Lordship, it's a commercial appeal also. Because they have sought for
Your prefer.
of the mobile.
You can seek time in execution
One
on the ground that the appeal is pending.
May I mention items 26 and 27?
Lord,
City urgency, Your Lordship.
7th of November.
my lord,
Monday, Your Lordship.
May I mention
serial number 65, my lord.
3, my lords. There's a contempt matter. There is urgency in the matter.
My lord, I am for the petitioner in this case, my lord.
The other side is on VC, my lord.
My lord, I'm on VC, I'm on for 34.
On which I have filed the contempt. And the hearing in the lower court is on 28th. Any earlier state?
8th of November.
My lord, my humble submission is, my lord, for 34.
70, 105.
Just 1 second, my lord. For
Because in
34,
the
my lord.
last 2 days earlier, we had made a mention and this court said it will take up the matter today. These are matters pertaining to a government corporation wherein compensation has been paid and received by them. However, thereafter, they have filed execution petitions, my lords. We have deposited all the amounts. We have been telling the executing court to hold on because the writ appeals are pending here. In the event the amounts are, my lords, withdrawn, they will stand to benefit twice on it, my lords. If there is early date, my lords, I will not compel the court to give a date, my lords, any date.
Compelled then 2nd December, yes.
My lord.
My lord, just one submission, my lords. My lords, serial number 34.
Yes.
My lord, my serial number is
Which date?
135. I'm contesting for.
2nd December.
I'm contesting for the
December.
respondent who has been terminated after retirement to ensure that he doesn't get any benefits. His medical, pension, everything has gone since May 2022. I'm praying around. He's a handicapped person. His wife is a cancer patient. They got to go for treatment. Kindly accompany.
13th November.
Tomorrow we can have it.
My lord, one submission, my lord. For serial number 34, the matter is listed for 8th of November.
13th November.
No?
13th November.
My lord, just one submission, my lords.
Sunday. 22nd November we can have it.
22nd.
Number
129, my lord, is on office objection regarding my council submission. Submission is that when a respondent has filed some photograph, that we can't produce. That's why we made a submission. Maybe come on fresh list.
Which is your number?
129, man.
Office objection relating, which was the office objection?
Regarding, man, we require to produce the photograph which was produced by the respondent, man. We produce the job.
Regarding production of
It can be over.
photograph is dispensed.
Serial number 44.
In the afternoon,
41.
May I,
interim order will be extended in all matters.
My lord,
may I mention items 26 and 27?
The student is required to pay her fees, Your Lordship, second year medical fee.
Tomorrow.
Tomorrow at 2:30, please, Your Lordship.
11.
Then day after tomorrow, please. There's some medical,
Tomorrow 11 not convenient,
tomorrow I'm not coming.
not come.
Mahesh.
Your lordship.
Day after, Your Lordship.
Day after.
Day after.
My lord.
And
Your lord-
serial- One more request, please, Your Lordship. Serial number 42. It was heard by Your Lordships at length, and it was understood both the parties, Your Lordship, are not being paid their salary. It was understood that it would be heard the next date, or unfortunately, it's not reaching. Can I request Your Lordship for a date? Any date at the afternoon, Your Lordship, so that 1.5 years they're without salary. They've succeeded before the learned single
Then
judge.
12th November.
Please, Your Lordship.
12th November.
Very well, Your Lordship.
Your lordship, serial number 130, your lordship.
Serial number 65, my lord, some early deal.
Date now will be.
Your lordship, it is a,
Serial number 18,
Your
my
lord-
lord. Writ appeal is filed insofar as not granting of interim order, my lord. The expedition date is on Friday, my lord. Kindly have it on tomorrow.
Get
your lordship, serial number 130, your lordship.
Tell nobody else.